Good afternoon, everyone. Myself, Anuj, founder Legal Desire, welcomes you all to this special occasion where we have two reasons to invite you all to this virtual gathering. Today, we mark our years of Legal Desire publication, and we dedicate this day to women and child. In the same direction, we are presenting the conference, which will discuss the legal facets of women and child rights. I am thankful to all the speakers who are joining us today for this conference. And before starting the proceeding of this conference, we would like to remember and pay our homage to the founders of Indian Constitution and also share with you a 7 years journey of legal design, media, and insights that we're doing all our efforts, uh, legal fraternity, and by training students by creating a platform on various law subjects that needs to be explored to learn the unexplored areas of law. Then our moderator, Ms. Mrinalini Banerjee, who is assistant professor at Chettinad School of Law. Legal Desire will start the proceeding of conference. So here's our journey.
उसको पंखे को ना वैसे भी नहीं आ रही, इसको हटाए के बाद
you
Yes.
so much for this amazing video. So, very good afternoon to the honorable guests for this session on the legal facets of women and child rights. I am Mrinalini Banerjee. We firstly want to welcome all the panelists on board today. Thank you so much for taking out time from your busy schedule, both sir and ma'am. And next, secondly, I would like to thank the entire Legal Desire team and especially Anup sir for making this possible today. So today's discussion is on a very important topic, that is the legal aspects of the women and child rights. And we know both women are one of the important aspects of the society. Both the children's right and the women's right are closely connected in context to the Convention of the Rights of Child and Convention against the Elimination of any forms of discrimination against women. Reading these two conventions, I can understand, according to my understandability, that if they both are together, it can enrich and promote the protection of children's and women's rights in three major ways. Firstly, the provision of CRC and CEDAW at many places overlap, and when they come together, it enables a more comprehensive, human rights-based approach looking into the various vulnerabilities based on both age and gender, looking into child and women together. While one convention addresses few issues concerned, the other convention is silent on that aspect. So it is advisable if we deal these two conventions together while dealing about women and child rights. Thirdly, in various instances, the protection of women's rights is important for the achievement of the child's right and vice versa. So consequentially, these two conventions are both mutually reinforcing and complementary. So coming to this end, I now end the brief note, and I would now like to introduce our one of the speakers, Dr. G.K. Goswami sir. He is a 1997 batch IPS officer of UP cadre and is currently on deputation to the Government of India, serving as Joint Director, Anti-Corruption, Central Bureau of Investigation, New Delhi. He has also served as the Joint Director, Central Bureau of Investigation, Lucknow Zone, Lucknow, Director of CBI Academy, Ghaziabad, and also as an expert on organized crimes in UN Office on Drugs and Crimes, and had an opportunity to visit across globe to share experience and views on wide spectrum of issues related to policing and law enforcement. In the state of UP, he served as a district police chief in various districts, which includes Lucknow, Agra, Varanasi, Noida, Moradabad, etc. He also rendered his expertise as operation chief while posted at SSP Anti-Terrorism Squad of Uttar Pradesh. The Honorable President of India has honored him the second bar by decorating 3 times with the Police Medal for Gallantry, the highest national award for police. He is also proud recipient of the Police Medal for the meritorious service conferred by the Honorable President of India. His Excellency, the Governor of Uttar Pradesh, has also conferred upon him Gold Medal of Gallantry. During his journey as public servant, he earned several commendations from the government of UP, senior rank and public at large. Pursuing academic interest while serving in police, he transformed himself into a student of law and won several gold medals in his legal academic endeavor of LLB and LLM. In 2018, he was awarded the second PhD from the Tata Institute of Social Sciences, Mumbai, on the subject enabling access to justice in sexual offences, role of DNA profiling. He is currently involved into research activities for fulfillment of DS from the Gujarat Forensic Science University, Gandhinagar. Recently, he has been selected for the Fulbright Nehru Academic and Professional Fellowship 2020 to 2021 with the Flex Award. Sir, with this, I would like to invite you to share your views on the thought. The floor is all yours, sir.
Onset of this discussion, I congratulate the organization, the desire, and the topic is very burning. And I have been assigned a task to conclude regarding sexual offense and intervention of forensics. Although the topic is wide, but I will try to discuss with you within 20 minutes. And then in the end, I think we will take up certain questions as and when it requires. So I will start my presentation. So I hope everybody is, this presentation is visible for everybody.
Yes.
My task is forensic intervention in sexual offense with children. And of course, I will deal with the male and female, both, whether it is child or an adult. So, dear friends, in the beginning itself, I am showing you some slides, particularly just see about the red boxes. One side it is charge sheet in last 4 or 5 years, because the latest report by the government of India on crime, this NCRB report, crime in India, charge sheet has been filed in rape incidents in nearly 90 to 95% cases. On the contrary, the conviction rate is hardly 30%. So this gap between filing charge sheet and conviction is nearly 60%, meaning thereby police believe that they have concluded their task, they have filed charge sheet, so their work is over. But when it is being tested during trial, the evidence are not sufficient and court is not able to secure conviction. So this is a dilemma. The same thing if you see the POCSO Act ever since from 2012, the scenario is same, police file charge sheet in nearly 95% cases, conviction is 30 to 35%. So my dear friends, this is a major task. We have to bridge this gap, and we will take up this point that how best the fair investigation, scientific investigation can be ensured in sexual offenses, whether it is with a child or with the adult human being. Another facet I want to bring your notice is the human trafficking, because human trafficking has direct linkages with sexual offense, be it a child or an adult human being. Don't go for this, clumsy statistics on the slide. Just see the red flag issues. Again, police file charge sheet in nearly 90% cases, but the trial conclude in conviction only in 20 and sometimes 30% cases. Just one more point I want to bring to your notice is the pendency in the court. In rape incidents, if you just see, pendency is nearly 90%. The same thing you can see even in the POCSO cases, and almost the same issue remain. The red, if you can see, the pendency in the court is nearly 91-92%. So this is the scenario, and we will talk how to bridge this gap and how to ensure justice. Because you see, whether it is UP case recently or earlier in Hyderabad, why people are advocating that instant justice encounters by police? Because somewhere people are not satisfied the court work, the police investigation, and I think this needs to be discussed in more detail. So let us enter into the domain of sexual violence. Although issue and challenges are large number, I cannot discuss every point, but I will just touch upon. If you see the legal premises of sexual offense in our criminal code, IPC. So harassment on one side is dealt under section 354 and 509. On the other side, assault 375 and then punishment in 376. My dear friends, before POCSO came into being, these sections were invoked irrespective of the age of the victim, whether male or female. Of course, for sodomy, still 377 is there, provided there is no consent and it is by force. I have also mentioned here about this civil remedy and criminal remedy. If you remember hashtag Me Too, the problem was that when the cases were unearthed or were disclosed after a very long time, then it becomes very difficult for investigator and even for the victim to prove their allegation with the cogent evidence. So it is a difficult preposition. It is a bumpy road. So I suggest them to go for civil remedy because there you need only preponderance of probability as far as evidence are concerned. But on criminal side, as you know, that we need evidence beyond reasonable doubt. So this is a debate, but because of paucity of time, I may proceed further. Now, these are the two basic, statute were brought once this Nirbhaya case was observed in year 2012, precisely on 16th December 2012. So Government of India brought Criminal Amendment Act because it was more discussed, and I think another one, sexual harassment at workplace, although they're almost at the same time it was brought up, but it was least discussed. But we will see how this has affected the jurisprudence of sexual offense in India. Dear friends, what are the challenges and what changes have been made by Amendment Act 2013? Broadly speaking, or precisely speaking, the major change in this new act, Amendment Act, was that it has widened the definition of rape under Section 375 beyond peno-vaginal penetration. Now, any part of body or any object, if it is being inserted or penetrated into any orifices or attempt is being made, orifice may be vagina, maybe mouth, maybe anus, or any orifices, nostril and something. But the problem here is that in traditional case, in mundane investigation, we generally collect evidence like semen, blood, or medico-legal examination and all. But suppose if finger is inserted into mouth, finger is inserted into anus or vagina, we are not able to collect forensic evidence per se. So this is a big challenge, and investigator face difficulties to prove allegation beyond reasonable doubt. So one side, we have expanded this definition based on Sexual Offence Act of UK 2003. But correspondingly, we are still lacking forensic evidence mechanism. We do not have the proper technique. So this is an area where R&D is required immediately. These are certain areas because I thought just to give some glimpse on POCSO. These are the objectives why we brought POCSO as a separate act, although it was basically to have alignment of our criminal jurisprudence, particularly with the children, with UNCRC 1989, because India is member since beginning. So these are certain objectives because of paucity of time. Anyway, the classification, if I talk about the child sexual abuse under this new Act 2012, my dear friends, one thing is very important to mention, that it is gender neutral. So there is no difference between a male child or female child. And then the term rape is, I think, cautiously being avoided to mention here. So the term they have replaced completely by another new term is penetrative sexual assault. So rape term is bypassed by term penetrative sexual assault. So penetrative sexual assault defined under Section 3, then punishment under Section 4. One another important point is that they have also mentioned aggravated word. So aggravated means that when the perpetrator is either family member, blood relative, or in a position of trust or dominion, like in a school, any hospital or something like that. Then for penetrative sexual assault, the quantum of punishment will be higher. So this is the scheme of things in POCSO Act. These are certain areas, salient features of POCSO Act. This is gender neutral. Both substantive and procedural laws are there. Then anonymity of child is very sacrosanctly being mentioned in that, and violation attracts penalties. Although Section 228A of IPC is equally applicable whether it is by male or female, maybe male or female, but maybe adult or minor. So 228 is corresponding section in POCSO is section 223. There are special provisions and many more things can be talked, but another important point here is alternative punishment under section 42. That means that if you invoke even IPC section in conjunction with the POCSO Act, then that section will be applicable where the quantum of punishment is higher. So that is alternative punishment, although it is a very debatable issue, but it is has overriding effect under section 42A. These are vital legal dogma and issues related to child sexual offense, statutory rape, Romeo-Juliet law. Just I want to bring to your knowledge what is Romeo-Juliet, because in many times, even in India, the adolescent girl, teenager girl, especially the girls who have age of 16 plus, below 18, they sometimes go along with their choice with their paramours. But whenever they come back, the parents generally slap criminal case against the boy. So how to deal with this? This is a big problem. So during my research recently, I submitted for DSC dissertation. So during my literature review, I found that Romeo-Juliet law in US is a good, suggestion where in case where the victim and the perpetrator or her paramour has the age gap of 3 to 5 years. So if the age gap is this much and the girl says that I went with my consent, then it can be dealt with a very minor type of punishment and it will not be tagged as rape. So these are few issues basically related to whether it is child marriage, independent thought versus Union of India is very celebrated case. Those who have interest can go through it. Compensation and rehabilitation is yet another problem in rape matters. Despite having clear guidelines by the government of India, the award of compensation is very, very poor. My latest research says that average allocation of compensation is nearly 11 to 12,000 only. Although it says that for rape cases, minimum compensation should be 2 lakh. So I think there are so many issues and challenges to be considered for better understanding. There are few defense pleas I want to bring to your knowledge that how defense actually proceed its case in POCSO matters. They generally talk about the inordinate delay if FIR has been lodged for very long time after incidents. Then prosecution has to explain the delay. So this is a weak point, meaning thereby that case should be registered as earliest after the reporting of the incidents. Second, majority of age and consent. My dear friends, in case of child up to age of 18 as defined under POCSO Act section 2D, once you prove that child is minor, then consent has no meaning, whether it is consensual or not. That means it amounts to statutory rape. So what the defense lawyer used to do, that they first try to bring the victim above the age of 18. And how they do, we will talk about the age determination part in the next slide, because in marginalized society, the age certificate are not properly maintained. The parents do not have the age certificate sometime, and there are a lot of complexity, and this is the gray area where defense lawyer easily beat the prosecution and get the easy way out, saying that the age of child or age of victim rather is major. And once it is proved, then it is very easy for them to label the allegation that it was consensual. And that allegation gets substantiated in case there is no injury on the private part in pelvic region. And further, if there is no corroboration, that means there are no scientific evidence like DNA or any other serological test, medico-legal injury. If such tests are not positive or not corroborative the allegation, then it is a fit case for the defense to get exonerated. So here the prosecution the NGOs and others who are in favor of the victim, they must think how to, overpower all these kind of scenario and situations. So this is age determination. My dear friends, although we have made a special POCSO Act, but there is no specific procedure how to determine age. Although we have the section under 34 part 2 of the POCSO Act that court has the power to determine age, but mechanism is not there. And this problem was raised in Jarnail Singh versus State of Haryana. And later there are other cases I have mentioned over there. In this Jarnail Singh case, court says that until and unless the rules or POCSO rules or the amendment in POCSO Act is brought in, then Rule 12 of JJ Act, and now it is amended, and the current section is 94 Part 2 of JJ Act 2015. So that will apply. That means for the determination of age, you have to apply section 94 Part 2. And what it says that how you determine the age of the victim, first get matriculation certificate. In case it is not available, then you go for date of birth certificate of the school. In case not available, then birth certificate from corporation, municipal, panchayat or something like. If all three are not available, then only you can go for medical opinion. So my dear friends, one cannot jump directly for age determination to go to a doctor, because the medical opinion has large ambit of suspicion. Suspicion means age variance plus minus 2 year minimum. So in those cases where the margin is very less, say 17 years, 17 and a half, 16 years, then there are other chances of error is very high. So this is a very, very critical area for the purpose of prosecution to get conviction. Here, this is one another point I want to flag is the intellectual challenged victim. These children are very sensitive. They get impregnated because of their ignorance and all. So I sensitize you that in case you get any such type of victim, please be cautious with them. Now, quickly rushing because time is less. So human identification is very important, and for the purpose of identification of the accused as well as sometime for the victim also, because if the victim is dead, body is putrefied, sometimes skeletal remains are there. So human identification remain important, and DNA is very important technology. And King Solomon justice, when two lady came into the court of King Solomon for the motherhood of a child, and he asked to bring a sword to cut the child into pieces. One lady cried, and he says that he is the mother. She is the mother. Meaning, to put this example is basically to reinforce that investigation is basically a scientific temper. You have to bring scientific mindset to the investigator. It is not merely the procedure, techniques, machines, and you have to have a scientific vision how to collate and connect the chain of evidence. These are certain areas of investigation. Because of paucity of time, I don't have time. What is the purpose of investigation? Pursuit of truth. Everybody in the criminal justice system is to assist the court and all. These are certain challenges for investigation of sexual offences. We'll talk about this. Delay in FIR, consent, then sole testimony, corroboration, and role of forensics. Consent is very important, my dear friends. The reason is simple, because sexual activity is a common phenomena. It is normal happening event, but consent is the legal tool by which you differentiate whether it is forced sexual activity or it is consensual one. So consent is very important. Sole testimony is yet another area which both prosecution side as well as the defense side must understand. What does it mean? It means that what the prosecutrix says, what the victim says, we have to believe it until unless we prove otherwise. because these type of offense are being committed usually in places of isolation. There is hardly any eyewitness, ocular witness. So court has given a very important doctrine called sole testimony, that you have to believe, but the testimony of victim must be believable, unblemished, and trustworthy. So these are the parameters based on which courts testify and ascertain whether there is a truth behind the allegation, and then they decide based on the other evidence. These are certain areas, because of paucity of time, because generally we try the case based on oral testimony, but they are subjected to interested witness and memory loss and many other things. So that way we need corroboration. These are certain cases of child sexual abuse, important cases. Those who have interest, they may look at it and can have better knowledge about the sexual offense of the children. Now let me enter quickly into forensic science domain. Forensic science basically is a helping tool for corroboration. And forensic science is a blend science. It is a mixture of many science, whether it is chemistry, biology, physics, and so many other aspects, serology. And what is the purpose of this forensic science to introduce in criminal side or even the justice system, courtroom? It is baseline for scientific investigation. It brings scientific temper actually. And it enhances the probability of evidence, the reliability of evidence. And overall purpose is to march towards perfect justice, so that justice can be ensured without any flaw. This is, my dear friends, although our Indian Constitution is Bible for any law emanate from this very premise of the law, but for the purpose of investigation and criminal justice system, Article 20 part 20 is very, very important, and particularly for forensic science, Article 20 part 3, that self-incrimination is important. Here in brief, I can just talk about a bit about what is first, second, third degree business in this criminal justice system. Everybody knows third degree. Third degree is use of power or brutal violence by police force. Why police use force during investigation on a subject? The purpose is to extract some information. That means collection of evidence or information is the purpose. Now, how to avoid that? The best thing is first degree and second degree. One should understand what is the difference. First degree means when you call a person, and here degree connotes about the quantum of torture, mental torture and physical torture. As I said, mental torture is permitted to some extent, but physical torture completely not. So first degree, when you call any subject to police station or for any investigation purpose, and you ask the general question, up to that level, that torture level is first degree. But the moment you start confrontation with the fact, so that is actual investigation, my dear friends. So those investigators who are well prepared, who know the entire case, and they have prepared a questionnaire before calling any witness or a person for examination, and then they confront the person with the facts and figures, then only it is the actual investigation. Otherwise, those who do not have preparation, those do not have the entire gambit of previous evidence and other aspect of the crime, so they resort to third degree. So confrontation is the key of investigation, scientific investigation. These are some Miranda warnings and all. I just skip. This is another point, the privacy, right to privacy. In forensic science, it is very, very important part. Those who have interest may read this privacy case, Justice Goswami. Both cases are important, whether it is informational privacy and all. Now, let me just quickly conclude my talk, because already time is there. Over. Forensic evidence collection. Where from we get forensic evidence? So local principle give this clue. Local principal exchange principle says when two bodies or two objects come in close contact, then they exchange some material. That means that when two bodies comes in sexual offense together, then body material get exchanged, maybe pubic hair, blood, semen, and saliva, and so on. So you can get forensic inputs from victim, accused, place of occurrence, and other places where some clothes or something like have been kept. So these are the probable area. Now this is one list. This is probable list. This is not exhaustive. It is indicative only. Forensic input may be medico-legal, bite marks, documents, fingerprints, cyber evidence. Cyber evidence is very important, digital forensics, because a lot of crime happens and it gives, maybe there may be some SMS, there may be some photos, there may be some location where crime happens. So it gives entire spectrum of crime scenario. So digital forensics these days becomes very important for sexual offense also. Deception detection technique, normally, they are generally used for the blind cases where you have no clue. But these are the inputs by these DDP are per se are not acceptable in the court. So you cannot prosecute a person merely if you say that the polygraph test is negative or positive or something like that. So these are only ray of hope in the dark. You can just proceed based on that, but you have to conclude with the cogent evidence. These are not cogent evidence, they are only helping to the investigator to collect further evidence. Chain of custody is very, very important part in forensic domain because it establishes the sanctity of the sample, the integrity of the sample. Otherwise, there are chances of manipulation and maneuvering of samples, and there are, I will tell you one case just in 2-3 minutes. So chain of custody is important. I have written recently an article published in Supreme Court Cases Journal. So those who have interest may go through that. Now let me talk quickly about the DNA. So what is DNA? DNA is basically science of wonder, and it is baseline for biotechnology. But how it enter into a courtroom, it is a just 1 minute story. Alex Jeffrey was the scientist who was basically working on DNA to identify human being, but not for the purpose of criminal investigation at all. At that point of time in 1983 and 1985, at two different places near London, two adolescent girls of age 12-13 years were brutally raped and then killed. They were cold cases, have no clue. So the investigator was same for both the cases. He caught one person called Richard Buckland, who was a boy of 21-22 years at that age, but having some mental challenge. He accepted one case to commit that crime. But the IO was, investigating officer was sensitive. He did not believe what he admitted, and he contacted Alex Jeffrey. They collected, he was courageous enough to take up that challenge, because at that time DNA has no connect with the courtroom. They took sample more than 3,000 persons, and at this time at that stage, one very important incident happened. One fellow called Colin Pitchfork, he was again a boy of 23-24 year old. He was sitting in a tea stall, and he made a disclosure there with his friend that, look, I have sent one fellow impersonified to give blood sample on my behalf, and he successfully did it. Sample was taken in the name of Pitchfork, but this disclosure was conveyed to police, and police caught Pitchfork, and then DNA matched, and this was the invention of DNA fingerprinting. But at the same time, I must tell you that our Dr. Lalji Singh has also big contribution in this field. He was from UP and had been director of CCMB Hyderabad. He was my guide also in my research work, and he actually made the contribution to make our Indian courts to understand the use of DNA forensics for the crime as well as for civil matters, especially for paternity determination. So these are the areas of legal perspective. Section 45 deals with the Evidence Act forensics, but Section 293 deals with forensic inputs for criminal cases only. Although there are so many things, but because of paucity, I'm just rushing. Here, I want to only add one thing: forensic fraud. My dear friends, forensic science, or for that matter, science per se, do not speak lie. But men behind science, those who are involved in the procedures, they can do blunders. And this case, Khurshid, this state of Delhi versus Khurshid, this is very recent case of 2018. Interesting background of this case is that in the same bench of Honorable Delhi High Court, 4 cases in back-to-back of child sexual abuse, all evidence, including medical report and many other evidence, were in favor of prosecution. That means that crime has been committed. But DNA report were consistently found in all 4 cases were negative. That means they were saying that accused is not connected by way of DNA analysis. Court got doubt and they sent all 4 samples to different labs. And to utter surprise, in all 4 cases, the new report says that it directly connects crime with criminal. So this fraud was ultimately caught, and Honorable Court sent this matter to our CBI, and now CBI has last year charge sheeted that lady DNA expert. So these type of things, my dear friends, we should not shut our eyes just by saying that it is forensic science, it is science. Science is, per se is very good, but we have to open our eye and ear before taking a final call. So this is the last slide. So we should professionalism, and of course there are so many things, but I think now we can take up the question answer session at the end. So I conclude with this, although I understand it is a kind of rushing, but I just thought to give some glimpse, some idea to my dear friends and colleagues to understand this very vast topic of sexual offense, by which every society, every country, every jurisdiction is facing challenges. With this, I thank you very much for patience listening. Thank you.
Thank you so much, sir, for your detailed discussion on this act and its challenges, and also letting us know what practically happens. Thank you so much, sir. We would be taking the questions at the end of the session. So now I would like to take the opportunity to introduce Mr. Prakash D. He is an officer of the Indian Police Services allotted to the UP cadre. He taught the University of Madras in the master's level in public administration and went on to research in the same subject to get an MPhil degree. He pursued master's degree in police management from the Osmania University, Delhi, Hyderabad. He was also posted as SP and SSP of 8 districts of UP. Before being promoted to the rank of DIG, he had served as the commander of 4 PAC battalion in UP. As DIG, he served in the communally sensitive areas of UP, such as Bareilly, Azamgarh, Allahabad, and Aligarh. He also had the experience of serving the Varanasi zone as IGP. During his service in the state of UP, he took special interest in women and child issues by attempting to streamline the inquiries and investigations in the subject. He is of firm view that community policing is need of the hour in India. Sir, I welcome you on board for this session. The floor is all yours, sir.
Good afternoon to all of you. Congratulations and best wishes to all in the Legal Desire on their 7th anniversary. And kudos to the organizers for choosing this topic, legal facets of women and child rights. Greetings to the moderator, Dr. Banerjee, and the fellow participants, especially my brother officer, Dr. Goswami, who had set the tone for today's discussion. I wish fruitful deliberations today. The topic which I have chosen is child trafficking in India. I continue from where Dr. Goswami has stopped. We are a democracy. We are proud of our country. But certain areas are there which trouble us. One such area is child trafficking. I believe that mostly this topic is behind the curtains. It fails to attract the media outcry or even the social attention for reasons well known to all of us. India as a country has a very huge volume of child trafficking. As per the reports of NCRB, National Crime Records Bureau, it says one child disappears in every 8 minutes in the country. Can you believe this? In our country, one child disappears in every 8 minutes. The enormity of the crime can be understood by the fact that the same NCRB statistics, it quotes that 1,35,000 children they disappear every year. All of us have been children. All of us, we have children in our families. We wish our children to have a bright future. But who will talk about these 1,35,000 children who vanish in our country? If you see the causes, what are the reasons why we have child trafficking in our country? We may have this in other countries also. The main, most important reason would be poverty. Poverty, we all of us know, it has cyclic effect. It affects almost every walk of life. The related reason would be unemployment. The parents, they don't have money, they're unemployed, they have mouths to feed and stomachs to fill up. So what will they do? They get away with their children, they give their children for employment, for other purposes. The weak law enforcement. I am grateful to Dr. Goswami for putting up the tone about law enforcement. Law enforcement needs to tighten its screws. The uneven social structure is another reason. We know about our country. We are proud of our society, our country, but we should accept the fact that the society is uneven on many accounts. Lack of education, lack of formal education throughout the country. It's a heap of ups and downs. Low esteem of girl children. Girl children are not welcome even today in many parts of our society. We know the reasons. The last reason I would dot would be traditional, cultural, and religious practices. One such practice I can say is the Devdasi system. Though we have a law which prohibits Devdasi system, all of us are together in unison that this should not be practiced. But even today, in many communities, this particular socio-religious trait is still practiced. So why child trafficking? If you discuss why child trafficking and what happens to these children who are trafficked, where do they go? Where do they disappear? Child labor. You see in any walk of life, you can see children being engaged in labor. I come from Tamil Nadu. Sivakasi is a place which was known for crackers, for matches, for calendars, and other entrepreneurial activities. At the same time, Sivakasi also had the ignominy of employing children, though situation has improved a lot. Begging. You can see child beggars in every important crossing of the capital of the country, leave alone other cities. Sexual exploitation. This has other facets also, like child prostitution, sex tourism, child pornography. We have had cases which have been discussed in the public domain. One case which comes to my mind is again from Uttar Pradesh, the Nitari incident, in which UP police had to draw a lot of flack, though later on the case was transferred to other investigative agencies. Justice was done, but the fact remains that around 40 women and children had disappeared during a gap of 2 to 3 years. And it took a lot of time, energy, effort for this case to be brought in the public domain. Domestic servants. Many children are employed as domestic servants. We should have the courage to stop this in our own families, in our own houses, in our own establishments. We should take the first step. Organ trade is another reason which has been flagged in when children are abducted, kidnapped, and they are forced to do away with their organs. When you see the map of a country, when you see the areas, which are the areas which are heavily dominated or affected by this vice, the poor areas of Andhra Pradesh, Madhya Pradesh, Uttar Pradesh, Gujarat, Odisha, West Bengal, Bihar, and in the south, you can say Karnataka and at some places of Tamil Nadu also. But the Northeast, I have served in the Northeast for 3 years in the Central Reserve Police Force, though it was not in my domain. But I've seen with pain children coming out of cases like this. Assam itself used to amount for 38 to 40% of the total cases in the country. So what should be the institutional response? What should we do? The country has come up with many regulations, rules, statutes. The first one, if we decide, would be the Universal Declaration of Human Rights 1948. Article 23 of the Indian Constitution prohibits human trafficking. This is the right against exploitation, the basic right given to all the citizens of the country. It prohibits human trafficking and forced labor. The Immoral Traffic Prevention Act, Section 370 of IPC, which was recently introduced after the painful incident of Nirbhaya in the capital of the country in 2012. Dr. Goswami had just now mentioned about this case. The punishment is imprisonment from 5 to 7 years. We also have the Campaign Against Child Trafficking, CACT, the Campaign Against Child Trafficking. So as educated citizens of the country, as aware citizens of the country, as people who can have a say in the system, what do we do? How do we help? How do we put in our share of stopping this vice of child trafficking? I would say the first and most important step would be the spread of education. We have the right to education. We have a very good educational system in the country. But the fact remains whether we have the same type of facilities to the children in the city, in the rural areas, or even in the remotest villages. As on today, I am sitting in Chhattisgarh. It's painful to see interior areas of this part of the country where people, especially the children, they don't have access to quality education. Awareness should be brought among parents. The parents should be aware of the rights of the children, and also they should be aware of the future of the children. Awakening in communities, as we had just seen, we have a few community vices, social and religious practices, which are certainly detrimental to the quality of life of an individual. The strict laws are already there. We had just discussed, the previous speaker had discussed about implementation of the laws. Laws are there, but the quality of the implementation has to be seen. And it's on our shoulders to chip in our part. We should also say a strict no to use of children in labor. Let it be any walk of life, let it be any facet of industries. There should be a strict no. Legally it is there, but then socially, as aware citizens, we must say a strict no to use of children in labor. Here comes the role of NGOs and the society. We have many NGOs who are working in this area, but all of us should come together. The 3P formula has been suggested by many thinkers: protection, prevention, and prosecution. You protect the children from vices like this. You protect the children and ensure a future for them, and you prevent cases happening like this in any part of the country. And if at all cases happen, then you prosecute the offenders. So what are we supposed to do? The national database for child traffickers. The national database for violators is already there, but then it should be used by everybody. Whenever somebody applies for a job, whenever somebody applies for anything, the first thing is we must check this national database whether the particular person's name and the details is it reflected in the national database. Information sharing and accuracy of information, this is one thing which we lag behind in our country in spite of our technology, the advancement in science and technology. We have the CCTNS system, which connects all the police stations of the country in one single platform. But then a lot remains to be done for feeding of the accurate information. First information reports, which starts the cycle of legal work, the investigation starting, the FIRs, the legal process starts with this. There should be strictly FIRs written, registered in all these cases, and the quality of the investigation has to be monitored by senior officers. I myself, I'm a police officer. The police departments all over the country, they share a larger responsibility and role in this to ensure quality of investigation so that the prosecution steps in and the violators are convicted. Clear SOPs should be laid down in the country for all this, for FIRs, for investigation, for prosecution, for handling of children. We remember the Muzaffarpur incident, which recently happened in the state of Bihar. The Supreme Court had to step in, and CBI was entrusted with the responsibility of investigation of this particular incident, which put all our heads hang down in shame. Help desks should be established everywhere, especially in the railway stations. The railway network is largely used to do this child and human trafficking. So help desks should be there in important railway stations, and a child-friendly atmosphere should be there in these help desks. We have something called AHTU, anti-human trafficking units. It is there in important places, especially the routes where children are trafficked. But then the quality of their working and their contribution should be clearly watched and improved. Role of NGOs, I've already discussed. We remember the name of Kailash Satyarthiji, who was even honored with the Nobel Peace Prize. There are many NGOs which have done human service in this to bring awareness of us, awareness of the society, to keep our eyes and ears open. The role of media is there everywhere. But the role of media should be positive in highlighting the cases, in bringing down the reasons, and in also highlighting the successes. The role of society, again and again, I would insist, society should come forward to shun these offenders, to protect the children, to ensure them a future. Finally, I would end in saying, role of you and me. You and me are the most important wheels of this system. And if at all it has to be improved, the ball lies in my court. I start with me, my house, my family, my department. And I would request all of you to join in this to ensure our children a bright future, and to also to ensure that vices like this, practices like this come down and the violators are brought to book. Once again, I congratulate all the participants and I wish good success to all of you. Jai Hind.
the students' knowledge and skills in the subject of forensic medicine. From 2015 to 16, she was a registrar at Neurology Columbia Asia Hospital, Bangalore, in which she used to assist patients on admission, take detailed history, physical examine patients, and also do pre-anesthesia evaluation of patients for elective and emergency surgery. She is an editorial board member of the International Medico-legal Reporter Journal since May 2020. Ma'am, I request you to kindly address our audience, and the floor is all yours.
Thank you. Am I audible? Mrinalini?
Yes, ma'am, you are.
Okay.
You're audible.
Good afternoon, all. So, like they introduced, my name is Dr. Vidusha Vijay. So, I will be focusing on the medico-legal perspective related to women and children. So, this is a really vast topic, and I won't really be able to go into the details of each and everything. So, I'll try my best to at least give you an overview of what I can talk to you about. So I'm sure all of us are aware the most common crimes against women are domestic violence, sexual harassment, rape, acid throwing, reproductive coercion. So this means it could be either pressure to conceive or have a baby or pressure to abort a child, either of the two. Then we have prenatal sex selection. That is quite common, especially in India, because of the need to have a male child. For some reason, our country, the population believes that a male child is necessary. So prenatal sex selection is ultrasound scanning done during pregnancy, and the sex of the child, if the child is female, then they would like to go in for an abortion. So we have laws preventing that now. It's called PCPNDT Act. Then there is female infanticide. That is, once the child is born, and if it's a female child, the child is killed. So that is female infanticide. We have dowry violence. We have marriage by abduction, forced marriage, and sex trafficking. So I will just touch upon a few which have medico-legal implications that us medico-legal experts are involved in. So one of the, very important is criminal abortion. So any abortion that is performed outside the purview of the Medical Termination of Pregnancy Act is called a criminal abortion. So the MTP Act, it allows abortions only in 4 scenarios. So these 4 scenarios are for medical purposes only. The law does not mention these 4 scenarios, but for the purpose of understanding and for medical implications of it, we have 4 classifications. So there is therapeutic. Therapeutic is when the continuation of pregnancy can cause some kind of complication in the mother. So that's when we recommend an abortion. That is therapeutic. Then there is eugenic. Eugenic is that when you know that the baby is going to be born with some serious physical or mental deformities. That is eugenic. We have humanitarian, which is done when the pregnancy is a result of rape or any other sexual assault. Then there is social. Social is when the pregnancy occurs when there is a failure of contraception. So maybe they are using some form of contraceptive, the couple is using it, and it fails, and there is a pregnancy as a result of it. Continuation of the pregnancy will cause them significant financial, mental kind of stress. So that is another reason when they can abort. And this termination is mandatorily has to be performed by a registered medical practitioner. It cannot be performed by a doctor who is not registered with the state. So it can be done only up to 20 weeks. So up to 12 weeks, one doctor can do it. And this registered medical practitioner is required to have training in the field of obstetrics and gynecology. So the law stipulates how long they need to be trained and all that. And up to 12 weeks, one doctor can do it. 12 to 20 weeks, we require 2 doctors to do it. At least 2 opinions from 2 doctors, and then one doctor can perform the abortion. And any abortion, criminal abortion, is punishable under section 312 of the Indian Penal Code. Then we have some other, I'm just going to touch up on this. Vitriol is acid attack or acid throwing. So section 326A of the Indian Penal Code describes voluntarily causing grievous hurt by use of acid. 326B is voluntarily throwing or attempting to throw acid. So both of this have very serious punishment, and there's also a fine amount. The fine amount goes to the victim for the medical treatment of her burns that is caused as a result of this acid. Then we have dowry deaths. Dowry deaths, section 498A deals with just treating the woman with cruelty. Need not be that she has to die. treating a woman with cruelty will be under Section 498A of the Indian Penal Code. And Section 304B of IPC is the death of a woman within 7 years of marriage due to cruelty or harassment by the husband or his relative for the purpose of dowry. So now that we've completed that, I'll move into a topic that I'm going to go into in some detail. So that is sexual offenses. So sexual intercourse that is performed against the provision of the law of the land. So every country has its laws. So any sexual intercourse against the law of the country, that is called sexual offense. So there are natural offenses, unnatural offenses, and sex-linked offenses or paraphilias. So natural offenses are offenses that are performed in the order of nature, as in the way it's intended to be. So there is violent, that is without consent. Consent has already been discussed by Dr. Goswami, so I'll not go into that. Then we have non-violent or with consent, that is adultery. But adultery has now been decriminalized. In 2018, there was a 5-judge bench which decriminalized adultery. So no, it's no longer a criminal offense. So Section 375 of IPC, I'll just take 2 minutes to go into the details of this because it concerns medico-legal experts. So what we are going to look at here is there are different, it's not just a penetration of the penis into the vagina that is considered rape. So there's a lot more to it. So there could be penetration of penis into the mouth, into the urethra, into the vagina, or into the anus. Any of these, it constitutes rape. So insertion of any object or any part of the body except the penis into the mouth is not considered rape. So say, example is right there, inserting a finger into the mouth, that's not rape. But inserting any object, even a finger or any other object, into the urethra, vagina, or the anus constitutes rape. Manipulating the woman herself to cause penetration. So forcing the woman to penetrate herself with something is also considered rape. It could be into the mouth, urethra, vagina, or anus. And application of mouth. So if the assailant applies his mouth to the woman's mouth, it's not considered rape. It will amount only to kissing. But if he applies his mouth to the urethra, vagina, or the anus, it constitutes rape. So the definition of rape under Section 375 has 2 parts to it. This is the first part. So what penetrates where and what does it constitute? Part 2 has part 1 has to occur under any of these 7 conditions. It has to be against her will, without her consent. Now, will and consent are 2 different things. Will is something that, let me give you an example. So if a child has to eat vegetables, he does not have the will to eat it, right? But if you tell him and convince him that it is good for you, he will eat it. So there is no will, but there is consent and he will eat it. So there's a difference between will and consent, right? Then there is putting the woman in a fear of death or hurt. Then there is when you have sexual intercourse with a woman where she believes that you are lawfully married. So you are not her husband, but then you have intercourse with her, that makes you susceptible under the Section 375 of IPC. Then there is when the woman gives you her consent when she is unable to understand the nature or the consequences of the act. She could be intoxicated or she could be mentally unsound. So in any of these circumstances, if she gives consent, that consent is not valid. And with or without her consent when she is under 16 years of age, which constitutes statutory rape. So the punishment for rape is under Section 376 of IPC. So I will not go into the details of this, but I want you to understand that there are different sections for everything. So we'll just understand just the highlighted words. So 376A is when the rape causes the death of the woman or causes her to be in a persistent vegetative state. That is a coma. There's 376AB. 376AB is a new clause that has been added in the Criminal Amendment Act of 2018. So that is when the woman is under 12 years of age, it stipulates a punishment for that. 376B is when a man has sexual intercourse with his own wife when they are separated and without her consent. They need not be separated, but without her consent, a man having sexual intercourse with his own wife is still rape. 376C is somebody who's in a position of authority. So it could be a public servant, it could be somebody who's in charge of a jail or remand home. It could be anybody who is in a position of authority. It's called a fiduciary relationship. There's 376D, which is when a woman is raped by 1 or more persons. So that's a gang rape. 376D is again a new section. This is when a woman under 16 years of age is gang raped. 376DB, also a new section. Woman under 12 years of age is gang raped. 376E is the punishment for repeat offenders. So those are the punishment. Now we'll go into unnatural sexual offenses. Once we understand the classification, I will talk to you about the medical examination of a victim. So sexual offense that is performed against the order of nature is called unnatural sexual offense. And here the act does not involve the penetration of the female genitals by the penis. So section 377 IPC, I'm sure all of you are aware, in 2018, it was decriminalized. So we'll come back to this. So anal coitus, oral coitus, lesbianism, tribadism, this is all now not criminal anymore under section 377, but bestiality, which is sexual relationship with an animal, is still unnatural sexual offense punishable under section 377. So section 377 reads that whoever voluntarily has carnal intercourse against the order of nature with any man, woman, or animal shall be punished with imprisonment for life or for a term of 10 years and also liable to fine. So in this now, any man or woman is no longer there as long as there is consent of the person. If there is no consent, then 377 is still valid. So this was a part of the British legacy, and it's decriminalized now, September 6, 2018. Then the third part of our classification, natural offenses, unnatural offenses, and then we have sexual paraphilias. So paraphilias are sexually arousing fantasies, urges, or behaviors. They are recurrent, they are intense, they occur for at least a period of 6 months. So we can diagnose it only if it occurs for a period of at least 6 months, and it should cause significant distress or interfere with important areas of functioning. So we have pedophilia. Pedophilia is sexual gratification by relationship with children. Exhibitionism is gratification by displaying your organs to another person, unsuspecting person. Fetishism is when you get sexual gratification by inanimate objects, objects that are usually not associated with sex. Then there is voyeurism. Voyeurism is sexual gratification by looking at another person undressing or taking a bath, when that person is not aware that you're looking at them. Then there is sexual sadism. Sadism is gratification that you obtain by inflicting pain on another person. Masochism is gratification by receiving pain. So somebody receiving pain and getting gratification is masochism. And you have frotteurism. Frotteurism is when a person rubs his genitals against another person in public, maybe in a bus or in a crowded area. So we'll quickly look at some of the laws pertaining to rape in the country that are applicable to medical experts. So section 164A of the CRPC says that the examination of a victim has to be conducted by a registered medical practitioner. Consent of a woman is mandatory. Even if there is a court order, I believe that the consent of the woman is mandatory. If the woman does not consent, you cannot examine the woman by force. And it has to be done within 24 hours of receiving the information of the offense. Examination of the victim of sexual assault. The report has to be prepared by the practitioner. There has to be the name and the address of the woman, the person who she was brought by, the age, the general mental condition, any injuries on her body, and description of the materials that are taken for DNA profiling. It has to precisely state the reasons for each of your conclusions. If you arrive at a conclusion, you have to state why you have arrived at that conclusion. It will record the consent of the woman, or the proxy consent can be recorded. In case the woman is unconscious, unable to give consent, or a minor, then you have to obtain consent from her caretaker or somebody who is legally in place for giving her consent. Then the exact time and of the beginning of the examination and the end of the examination has to be recorded. And the report has to be immediately forwarded to the IO. The IO will send it to the magistrate. There is section 273 CRPC. So if the victim is a minor, then the court has to take measures to make sure that the victim is not confronted with the accused. So this applies even to the investigating officer. So the victim and the accused should not be brought to us together, and they should not be confronting each other. So there has to be, they should be separated at all times. Then we have section 327(2) of CRPC, which means an in-camera trial. So it's a Latin word. Camera means a vaulted room, which means that in this scenario, a judge's chambers. So this trial of such a case is conducted in chambers, especially in POCSO, so that there is no the victim is not unnecessarily paraded in front of the public. And any proceedings from such a trial cannot be published without the permission of the court. Section 357C states that all hospitals, could be public, could be private, you have to immediately provide first aid to the victim. free of cost. You cannot say she has to pay or you cannot refuse treatment. First aid has to be provided to all victims under sections 326A, which is vitriolage, 376, which is all rape sections. And you have to immediately inform the police. That is also the duty of a doctor. In the Indian Penal Code, 166B is relevant. So anybody who contravenes the provisions of 357C, which is what we spoke about just now. So the doctor is mandated to provide treatment. So if you contravene that, under 166B, you can be prosecuted, imprisoned for a year, or fine, or both. 114A of the Indian Evidence Act says that if a woman states in her evidence that she did not consent, then the court will presume that she did not consent. So the burden of proving that she did not consent lies on the accused. It's not the woman who has to prove that she did not consent. And in section 146 states that there can be no questions on past sexual practices or her general immoral character. It's only that in that particular episode she did not consent, and that's it. So coming to the medical examination. So the Ministry of Health and Family Welfare of the Government of India has released guidelines and protocols for the medico-legal care of sexual violence victims. So the guidelines, I will just go briefly. So we do start with the initial resuscitation or the first aid. Once she's stable enough, then you can take an informed consent if she is conscious, consent by proxy if she's not conscious. Then you do a detailed history. So you take a history of everything that occurred, where she went, what happened, everything in detail, and you document it. And then there is medical examination. You start with the general physical examination, and then you examine her local injuries, the genital area. And age estimation only if requested. If age estimation has been requested in writing, then you can do examination by physical examination, you can do a dental charting, or you can take a X-ray to examine her age. Evidence collection, there is something called the SAFE kit that is available. SAFE. SAFE stands for Sexual Assault Forensic Evidence Kit. So I'll come to that a little later. Then documentation. So every single thing that the doctor has noted has to be clearly documented in a form. Once this is documented, the evidence that has been collected has to be packed, sealed, and handed over to the police. Once that is done, the next primary concern as a doctor would be to treat the injuries. So immediate medical attention, treat the injuries that she has sustained. She has to be tested or given prophylaxis for HIV or any other sexually transmitted diseases, including hepatitis B, and also check for pregnancy. Then you have to give her psychological support and counseling. So this is what I'm trying to highlight here is it is a multidisciplinary approach even for a medical expert. It is not only the forensic expert, it also involves obstetrics and gynecology. It also involves psychiatry. So it's a multidisciplinary approach to treat such a victim. And then finally, you have to refer her for further help. So most hospitals, especially the government hospitals, have something called a one-stop center. One-stop center will also have somebody to give her a legal aid. So you refer her to that person so she can seek some shelter in case she needs it and legal counseling. So this is the SAFE kit that I referred to, Sexual Assault Forensic Evidence Kit. So this is how it looks like. Contents will be, it will have forms for documentation, pre-printed forms that you can easily fill. There's a large sheet of paper. So the woman is asked to undress over the sheet of paper so that no evidence is lost. Then you have paper bags for collecting the clothing that she was wearing at that point of time. There is catchment paper for trace evidence that you can collect. There are sterile cotton swabs for collecting evidence from the local area. Then we have a comb for combing out the pubic hair and collecting any evidence from there. We have a nail cutter and a wooden stick. So fingernail scrapings are taken, nails are cut, and it's also stored as evidence. We have scissors. There's a urine sample container. There are containers for blood sample collection. There are syringes for drawing blood. There's some distilled water. There are disposable gloves. There are glass slides for preparing slides of the swab that you have collected. There are boxes for storing the evidence samples, labels. There is wax for sealing it. There's clean clothing may not be there, but there will be shower and hygiene items in the kit. And other equipment that we use, these are not in the kit, but these are the equipment that we usually use for the examination of a victim. So this is the form that is used in our setup in our hospital, Victoria Hospital in Bangalore, under Bangalore Medical College. So we have the initial part. So this gives you the preliminary data, who you receive the requisition from, at what time, the name of the victim or the accused, and the crime number, and accompanied by. This has the details of the individual, the name, the address, the age, the identification marks, and here is the place where we document the history. Then we move on to general physical examination. This has all the basic details of the individual. This is the local examination. This will document all the injuries in the local area. If there are any more injuries on the back of this, you can always write it down. And this is your final opinion. So usually we comment on number 2. We do not comment on number 3 because there has been a Supreme Court ruling that has stated that we are not allowed to comment on whether the individual is used to or not used to sexual intercourse. That is not permitted anymore. So the only thing we will be commenting on is point number 2. So on local genital examination, evidence of signs of recent sexual intercourse are present or absent. That's it. So this is something I want to stress about. So the doctor's job, it is not to determine whether the rape has occurred or not. It is our duty only to document injuries and to state, I will come to it a little later, how we state it. But we are not going to comment that the woman has been raped or not raped, because that is a legal term and it is up to the honorable court to decide whether it was a rape or not. So how we formulate our opinion based on genital injuries, physical injuries, and FSL report. So if genital and physical injuries are present and FSL says positive for semen, then we will say that there are signs of forceful vaginal or anal intercourse. Never the word rape. Forceful vaginal or anal intercourse. If genital injuries are present but no physical injuries and semen is present, then there are signs of forceful vaginal and anal intercourse. It's the same. But if genital injuries are absent and physical injuries are present and there is semen too, then we will again say there are signs suggestive of forceful vaginal and anal intercourse. Injuries in the genital area or any other physical injuries are not mandatory for it to be rape, because woman might have consented but might not have had the will. That's where will and consent come into play. But that's not for a doctor to determine. It's for the honorable court. So then we have, if genital injuries are absent and physical injuries are absent, but it is positive for presence of semen, then there are signs of vaginal or anal intercourse. So there is no forceful here because there are no injuries. If both are absent and it's positive for semen as well as some drugs or alcohol, then we will say that there's signs suggestive of intercourse under the influence of drugs or alcohol. In case of non-penile penetration, there will be genital injuries, there are physical injuries, FSL report is negative, then there are no signs of vaginal or anal intercourse, but there is evidence of physical and genital assault. So there is no intercourse that has occurred, but there is some sort of genital and physical assault. Here there's present, genital injuries are present, physical injuries are absent, FSL report negative. So there's no signs of intercourse, but evidence of genital assault. Genital injuries absent, physical injuries present, FSL report negative, then no signs of vaginal or anal intercourse, but evidence of physical assault. Both absent, FSL also negative, then you have to state that there are no signs of penetration. Both absent, FSL report positive only for lubricant, then this penetration by a lubricated object. So this is how a medico-legal expert will give an opinion. So short-term psychological effects are present on the victim, and there are also some long-term effects. We'll not go into that. So I want to stress on this. So what can you do? So as somebody who is not a medical expert, what can you do if you're at a scene of crime? So there are two things. One is chain of survival, two, chain of custody. Chain of survival makes sure that the victim stays alive till she reaches the hospital. So when you come across the victim of sexual assault, first step is to ensure that she is safe. So you take her to a safe or a secure place, call the police if there is danger from the assailant. If the assailant is still around, call the police. Then ask her and call her close friend or relative if she's conscious, somebody who can support her in this time. And one other thing is pelvic binder. So as a lay person, you can do something if there is a lot of genital bleeding. This is only if there is a lot of bleeding from the genital area. You can use something called a pelvic binder. So I want you all to watch this video. It's just a short 45 seconds video. This is how you apply a pelvic binder. So you take a bed sheet or any other long cloth that is available, could be a dupatta, bed sheet, something. So it usually needs two people, but one person can do it too. You put it under the person and then you tightly rotate it. Yeah, this is how it's done. So you tightly rotate it about 3 to 4 times. So this will put pressure on the vessels in that area, pubic area, and reduce the bleeding. Yeah, so you tuck one at the bottom, one at the top. This will control bleeding till the victim can go to the hospital. So I want you all to tell you all that if this was done in Nirbhaya's case, she would probably have survived. She had massive bleeding from her genital area. All right. So then we have the chain of custody. So chain of survival is for the victim. Chain of custody is for the accused, sorry, the evidence, which will help us convict the accused. So you take care not to clean up before taking the victim to the hospital. Don't clean her up. So ideally, she should not bathe. She should not use the washroom, not comb her hair, change her clothes, brush her teeth, none of this. She should be directly going for medical examination so that all the evidence on her can be collected. So this is what you can do as laypersons. So my talk would be incomplete if I don't just specify a few of the points about violence against children and minors. So child abuse, it is the physical, sexual, or emotional mistreatment or neglect of a child. So there are 5 categories in child abuse. One is child neglect. Then there is emotional and psychological abuse. There is child sexual abuse. There is physical abuse and chemical abuse, which is intentional poisoning. So child neglect is an act of omission. That is, the child is not given something that they deserve. That is their right. Maybe adequate food, clothing, hygiene, school, getting appropriate medical care. If any of this is eliminated, then the child is being neglected. Then there is emotional and psychological abuse. That is degradation of the child, destruction of the child's personal belongings, excessive criticism, humiliation, name calling. All of this is psychological and emotional abuse. Then there is child sexual abuse. It need not be only just having sex with the child. It could be indecent exposure of genitals to a child, forcing the child to watch some pornographic material. All of this constitutes child sexual abuse. Then there's chemical abuse or intentional poisoning, which is administration of toxic substances to a child. In physical abuse, there's the usual. There is burning the child, there is electrocuting the child. But there are 2 other things which have names, syndromes, battered baby syndrome and shaken baby syndrome. So battered baby is usually a child less than the age of 3 years. So this is an unwanted child. So they're not wanted by the parents or the caretaker. So this child is beaten repeatedly over the most trivial provocation. So it is the smallest of things, but the child is beaten repeatedly. So the history given by the parent or the caretaker is inconsistent with the injuries. What you observe is that there are injuries of different ages. There's a bruise that's 1 week old. There could be a fracture that is 6 weeks old. There could be another fracture that's 2 weeks old. There are many injuries, all of which do not match the history given by the caretaker or the parent. Then there is the shaken baby syndrome. In shaken baby, there's a constellation. It's a number of signs and symptoms, but all of this is because of violent shaking of the head of the child. So there is brain damage. There is extensive retinal damage. Retina is in the eyes, at the back of the eye, so there's damage there. And there's fracture of the long bones of the ribs. So if you look at this, the image here is battered baby syndrome. So what you observe is that there could be some bleed here in the brain, subdural hematoma, some skull fractures, maybe a black eye from a punch to the face, swollen lips or broken teeth because of a slap. There are bruises of different ages, fractures of different ages. There are ruptured viscera. So inside the body, the organs could be ruptured because of the beating. Then there could be bruises of different ages, whip marks if hit with a belt or another rope or something. Shaken baby is the baby is held like this. It's usually a smaller child and the baby is shaken excessively. So there is a lot of movement of the head. So this causes damage to the brain, which could result in permanent mental difficulties for the child. And because of the grasping of the child, there could be fractures of the ribs or the long bones. So POCSO Act has already been covered. So I'll just quickly brush through it. So it was formulated in 2012 to deal with sexual offences against children. In 2009, there was an amendment. So there are 46 provisions. So it increased the scope of reporting offences against children, which was not earlier covered in the IPC. It provided procedures for recording the statements of the child and also by the court, and so that it's done in a child-friendly manner. And there are also special courts that are done for the trial of POCSO cases. So what is relevant to us is these different types of assault. So chapter 2 describes sexual offences against children and the punishment. So there is penetrative. So penetrative is everything that I spoke about in section 375 IPC, that is rape. All of that. So it could be using the penis or an object or forcing the child itself to do it or applying the mouth to urethra, vagina, anus, or even the mouth in some cases. So all of that is the same as penetrative sexual assault. Aggravated penetrative sexual assault is the same as penetrative, but it's done by an individual who's in a position of authority or somebody who the child trusts. Or if you use some deadly weapon, use fire, use a corrosive substance, or if the child is mentally ill. Then we have sexual assault. The term sexual assault means any act that is done with sexual intent, which involves touching the child physically, but there is no penetration. So that is sexual assault. Aggravated sexual assault is the same, again by a person in a position of authority or trust. And then there is sexual harassment. Sexual harassment is making a gesture with sexual intent or exhibiting the body to the child, making the child view some pornographic content, or use filming content that has the child and then threatening to use that content. All of that is harassment. Chapter 3 of POCSO Act describes using the child for pornographic purposes and its punishment. So this pedophilia, that is the sexual interest in a child, is not something new. It has been around for ages, centuries even. So it's described even in the Bible, in the Old Testament. And there are scientists who have spoken about this. And I want you to remember this person, Lewis Carroll. Lewis Carroll was actually a famous children's author. He wrote books like Alice's Adventures in Wonderland. He was a known pedophile and even a Nobel Prize winner of 1976. He has been criminally charged with child molestation. So these molesters of our children are all around us. So what can you do? You can teach young children the 4 personal parts of their body and how nobody can touch that except their mother, not even the father. So it's important to teach children this. Also, little older children regulate their use of internet. Pedophiles actually stalk children most commonly on the internet. So that's what you can do. These were my references. Thank you.
Thank you so much, ma'am, for your insight about how medico and legal things have been come together and they're blend together into the aspect of women and child rights. So I now like to introduce to you all the next speaker, which is Ms. Pallavi Mahajan, who's a gender advocate working for economic independence and social visibility of genders. She is also the co-founder of an intersectional feminist NGO called the Azaad Initiative, which has recently received the UN volunteer status. As the United Nations 2019 Gender Fellow, she has worked closely with the marginalized gender community in India on diversity and inclusion at the workplace through policy and activism. She is also the India representative of the Global Goodwill Ambassador to carry forward the women empowerment in 192 countries and team lead for UN volunteers. She is an invited fellow to work for women equality at the Royal Society of Arts, London. She recently received the coveted Chevening Award to begin her Masters in Gender and Development at the IDS University of Sussex in September 2020. Ma'am, I request you to kindly address the audience.
Thank you so much. Before I begin with my presentation, I would like to share the screen so that the logistics of the presentations are in place. I hope the screen is visible. Perfect. Thank you so much for a very, very kind introduction. As stated by the moderator, my name is Pallavi Mahajan and I am a gender rights advocate. And for today's presentation, I will be focusing on the confluence of the movement of gender equality and economic growth. Just a minute, I'll just expand the... Sorry, yeah. So yes, as I stated, my presentation topic would be on the gender equality, the confluence, the intertwined nature of gender equality and economic growth. And we'll start the presentation by addressing the key issues, that is to understand that where is the data. It is very important to address the data in the house so that we can understand that where are we lacking around. So India, out of 129 countries, ranks 95 in the Gender Global Equality Index, which means that the parity between the genders, India is in the lowest bottom of the countries around the globe. 70% of India's poor are women, when the percentage of women in the country is 49%, and out of the poor in the country, 70% of them are women. And even when poverty is indexed, 36%, there is a higher rise of females to be induced by poverty than by men. Indian economy, it has been stated that had there been a gender parity as far as economic distribution was concerned, the Indian economy would grow at a rate of 9 to 10% every year. The GDP of the country would grow at that rate. Also, in addition to this particular data is that India every year loses 1.8% of its GDP just to homophobia. So we do not tap on the pink dollar economy as it is stated. The accounted for contribution of women to India is 24% only. And this is when, if you take into consideration the kind of professional schools around India, be it engineering schools, be it medical schools, be it law schools, the percentage of women who graduate from these schools is 64%. And then when it comes to women contributing to the GDP of the country, the data is only 24%. Then every year, and specifically it has been reported during the COVID times when the home itself was not considered for certain women a safe space, 48% of the women, as quoted to the National Commission of Women, succumb to workplace gender bias. So what are these workplace gender bias? These are basically where the primary caregiver at home becomes a woman, or there is an emotional, physical, sexual abuse due to which women have to give up their careers, or an unplanned pregnancy, or lack of infrastructures available to women to carry forward their careers. 86% of women have reported that they are primary caregivers at home. This is no rocket science, that caregiving happens to be the primary key result area of a woman, even if she is bringing bread at the table, even if she wants to pursue a career. For her, it is a stereotypical socioeconomic setup that she has to be the primary caregiver of a household. Then India ranks 149 out of 193 countries in the Women at Legislature Index. So this is basically about the representation of women at the parliament in the various legislatures. And why is it important is because any kind of policy related to women will only be materialized, will only hold gravitas once there are women as role models who vocalize in these policies. And the political process in the country is very skewed as far as women representation is concerned. And the last is that even though women in their domestic chores, which is supposed to be in the most utopian land, a gender equal ground, women spend about 352 minutes working in a household as compared to men who spend only about 51.8 minutes. And even then, the care economy, the labor at home is unpaid for and unaccounted for. So this data totally gets into consideration that how the representation of women, how gender disparity in the economy has a direct reference to how the economic growth in a country, specifically in a country like India, will progress. Now this is data, right? Now let's come to understand that what is in fact the causality of action between gender equality and economic growth. So gender is not just a socio-cultural term that is used to show that how wonderfully well a country is progressing as far as its culture, its values, and its human rights are concerned. Gender is a key analytical element to understand economic development. And why is it so? If we take into consideration India as a country, 49% of the country, 49% of the demography of a country is women. And if we do not take into consideration their economic contribution, the GDP will not be able to reap the most of its benefits. The economic contribution, as I mentioned above, is a culmination of market work and unpaid work. Now, how is unpaid work a very important part of the economy is because once the labor of domestic household is taken care of, the productivity at work increases. And why is it so? Because of the emotional and the materialistic well-being of the person who is bringing bread at the table. The gender distribution of material resources and masculinization of opportunities. This is a very, very obvious truth that material resources, if we take into consideration even post-COVID times, or even in the times of any kind of global calamity that has happened, the maximum resources are spent in infrastructure services where men are dominated in a career field, be it be manufacturing units or construction units, rather than focusing the quantum of distribution of wealth in areas, say nursing, teaching, etc., because these are women-dominated fields. Even with masculinization of opportunities as a field is concerned, in certain areas, it is considered that women are a burden to a certain part of economy. They are risk investments rather than taking them into consideration as assets to an organization or assets to an economy, and therefore the economic growth is always hindered with women as subjects. Now, coming to the macroeconomic policy, be it finance, legal, health, public expenditure, etc., all these actually emerge from the confluence that gender shares with economic growth. So when credit facilities for women entrepreneurs is not available, how will a woman try to will carry forward her dream of becoming a startup owner or an entrepreneur? Similarly, when legal knowledge is not disseminated in a gender equal fashion, how would a woman get to know that her rights and her rights are equally vocalized by the constitution and the various statutory laws of the country? Now, India is more so a patriarchal country where, even though we are talking about gender equality and sustainable development goal number 5, male happens to be a breadwinner model. So the breadwinner model is sanctioned throughout the country, even in the most developed parts of the country, where even though woman is getting income at home, that is considered as an ancillary income. And similarly, in an agricultural economy, a man is considered to be the head of the economy. Now, in both these scenarios, what really plays to the handicap of a woman and her economic independence is the power dynamics. A male breadwinner model or a family head in an agricultural economy will start being the decision makers of a particular household or a particular economy, and hence will take away the right of economic independence of women. And coming to the last, the economic of lack of representation and role models. Now, we've already discussed as to how the lack of representation of women at the parliament and various legislature modules plays a havoc on women's ambition, but also role models, lack of role models in leadership. Do not let women pursue their careers and ambitions because they feel that it's an all-male panel as we call it, an all-male body, and therefore they are not able to see their allies, which hinders their growth and their ambition. Now, this is a kind of a flow chart as to how gender interplays with economy. Now, we will start and pay attention to certain intricate parts. So all of it is very important, but certain intricate parts of this particular flow chart we'll pay importance to. Now, starting with the first is access to infrastructure services. Now, the infrastructure services are both macroeconomic and microeconomic services, legal, finance, public expenditure, as we discussed in the previous slide. And they are divided into two parts. That is time allocated to home production and time allocated to child rearing. Now, home production and child rearing are basically, as we discussed, primary caregiving models for a woman. And once time is allocated to there, the time left goes to market production, which is our market economy. Now, if women are allocated more as primary caregivers, their time allocated to market production obviously becomes less, and therefore their productivity at work becomes less, which leads to lack of women's health and education. Because then if women are not contributing to the GDP of the country, or they are not active contributors to the growth of economy, their education is considered as a burden. And similarly, any kind of investment for the emotional health or physical well-being of a woman is also considered as an unnecessary investment, and which leads to, again, a vicious circle of low productivity, less market production and market consumption, and low consumption and low incurring of family resources. Because in this particular scenario, there is only one person who is getting active income at home, even though the other partner wanted to bring, but the whole socioeconomic fabric is as such that the right opportunities are not available. And this also leads to low in wage income. And similarly, a detrimental effect is put on the growth of a progeny of this particular family, because that progeny is being taken care of by the primary caregiver, who is a woman. The child's health, the child's education, the child's way of looking at stereotypical gender roles in an economy are also hindered. So therefore, this vicious circles which starts with the access of infrastructure services, which emerges from economy, goes on to the various microeconomic fields of legal, finance, medical, as we discussed, as we were acquainted to in the previous expert panel, that how Even the medical infrastructure is belittled as far as gender control is accessed. And therefore, this entire nexus plays into how economy and gender play a trivial part in their confluence. Now, coming to understand as to why there is low participation of women in workforce. Now, there are certain, obviously, views which are very stereotypical, but I have tried to, due to paucity of time, because we are running against time, I've just bracketed it into certain pivoted points. First is that we have already discussed that as a socio-cultural fabric of the country, we are a country which believes in the male breadwinner model, and the income of the woman, the ambition of a woman is only considered as the ancillary part of a household or of an economy. Already discussed that the woman is a primary caregiver in a household, and therefore the time allocated for other for participation in the economies is almost negligible, and therefore there is low participation of women in workforce. Coming to the third, which is traditional and non-traditional industry segmentation. Now, this is a very important point to consider, specifically how we stereotype genders into various boxes, where women are considered to be kind of more agile to work in certain industry segments, and men are supposed to be more agile in other industry segments. Now, this would be okay had it been an equal distribution of industries and an equal distribution of choice. But what we have seen over years is that the segments of the industry which contribute massively to the economy of the country are the segments which are male-dominated, and where participation of women is barricaded under various kind of boundaries. Now, wage differential and education and income, gender pay gap, education gap, and distribution of income is not just a corporate economy goal. But even if we take various other sectors of the economy, be it be agriculture, be it be health sector, or be it be even social sector, there is a major gap as to what women work and how they are paid. Wealth, both in inheritance and in self-acquired wealth, though the inheritance laws in the country have become a little more gender equal, but even then, there are major loops as to how wealth is bent towards one particular gender and not takes into consideration women as an equal voice in distribution of wealth. Now, coming to social institutions and inequality. Now, various social institutions, by social institution, be it be Panchayati Raj, be it be the other statutory cells of the government or civil societies, are seen that the decision-making body, the leadership body at these institutions is men, and therefore the angle of the needs of women is missed. Now, infrastructure is an economic barrier to participation of women. What we heard as safety regulations, we have been discussing POCSO, we have been discussing prevention of sexual harassment at workplace. But if infrastructure, be it be safety, a safe space, or protection by various government resources is not imparted to women, women will always be at dagger's end to join the workforce. Labor regulations discriminate against women. The Equal Remuneration Act is out and working. However, the unconscious gender bias at work is always prevalent to make sure that women are always underpaid and their participation is always rationed. Lack of social protection, as we discussed in social institutions and so infrastructure as economic barriers of participation of women. The social protection given by the women by various statutory bodies and the government representation is almost negligible, which hinders their growth and their ambition calls. Lack of availability of care. Under the Maternity Benefit Act, there is a provision of creche facility available, but how worthy are these creches? How sanctioned are these creches is a question that has to be addressed. And because of lack of availability or lack of address to the care economy, women are not able to go out of their primary goal of a caregiver and address their goal of equal participation in the workforce. There are discriminatory entrepreneurship policies which might not sound discriminatory on paper, be it the Startup India campaign or the various other one-stop center campaigns specifically for women entrepreneurs. However, be it be credit facility, be it be mentorship opportunities, women are always considered as the last slot in the entire food chain. There is not a lot of active participation by the infrastructure resources to make sure that women are taken care of. And the last is lack of access to finance, be it in a household where we have discussed where male is a breadwinner model, or in the credit facilities. Women do not have equal access to finances as their male counterparts to take forward their goal of contributing to the economy. Now, this was the economic provision, the economic setup as to how women, even though they want to contribute, but because of gender disparity, gender inequality, they are not given equal resources to participate in the economy. But let's come to understand what are the legal provisions available and where are they lacking? What are the recommendations available to make sure these legal provisions, which are based for economic empowerment of women, can be little more sanctioned and structured. Now, coming to the first, we have discussed in detail by the other esteemed panels on the sexual harassment of women at workplace bill and now an act. This was one of the most important legislations, and personally for me also one of the most comprehensive legislation, which are even in the post-COVID times as relatable as it was in the pre-COVID times. Sexual harassment, until and unless we give a safe space to women to take forward their goal of becoming active contributors to the economy, the women will never be able to come out of this jail. And sexual harassment of women at workplace, the POCSO Act takes care that women are protected. Even in the post-COVID times, it takes into consideration the remote working of women, which is be it work at home or remote working where they are not confined within the walls of a so-called work infrastructure. Now, coming to the Equal Remuneration Act, which says that there has to be no disparity or discrimination amongst genders, and the only payment is to be to people who access the same uniform. So what is important here to note that the Act clarifies that uniform is supposed to be the key word to decide the equal remuneration of the genders. So if there is a particular job description or the genders that are working in that particular job are disseminating their services in the same fashion, have come with the same kind of experiences, same kind of knowledge, same kind of bandwidth and skill set, they are supposed to get equal remuneration, and there cannot be any discrimination just based upon gender. Now, coming to the Maternity Benefit Act, which was recently amended in 2017, by the virtue of which creche facilities, 12 weeks of paid maternity leave, and no discrimination when a mother joins back the workforce were augmented by the virtue of this act. However, the Maternity Bill Act, vis-a-vis the Paternity Benefits Act, which is pending right now in the Lok Sabha, has come into a legal purview, because with the ongoing nature of Maternity Benefit Act, we go back to the age-old norm that caregiving duty is a woman's duty. But with the Paternity Benefit Act, this gender discrimination of care economy is put to rest, because now through the Paternity Benefit Act, which is though pending in the Lok Sabha, the caregiving model is made gender neutral. Now, coming to the reservation for women in local self-government, 1/3 of the seats at the local self-government, which is the Panchayati Raj, is to be reserved for women. But how well does it counter the age-old patriarchy that India as a country goes through? It has been seen over years that even with this reservation policy, at the Panchayati Raj, women are basically the mouthpieces of the men in the family. And even though they are able to take up certain places, which most of the time is vacated, is a vacant place, because women are not given the opportunity to even contest the elections, even if there's a reservation quota available. And even if they take their place, they're only mouthpieces as to what is decided in between the four walls of the household. Now, coming to the National Plan of Action for the Girl Child, which is against feticide, infanticide, which is against child sexual abuse, which is against any kind of discrimination for a child, for a girl child. The policies what appear on the paper are are expansive. They take into consideration the socio-culture and the diverse background of India. But when it comes to the execution, be it in the form of the executive machinery or the investigating officers, there is a huge lag that has been observed as to what appears on paper, what is the policy that has been laid down by the legislature, and how well they are sanctioned by the executive machinery. The National Policy for the Empowerment of Women, which came into being in 2001, takes into consideration every and any kind of an abuse, sexual, physical, emotional abuse of women at various junctions of her life. Similarly, it takes into consideration the empowerment policies related to women, which is not just an economic empowerment policy of the women, but also an empowerment of choice, an empowerment of consent, an empowerment to take forward and to vocalize the views that women might have, even if they are contrary to the majority view of a household. And coming to the last, which is the National Commission for Women, which I'm sure most of us are aware of, is a legal statutory body of the Government of India, which takes into cognizance the various needs, the various wants, the various rights, and the various requirements of women as a demographic profile of the country. Now, we have discussed what are the legal frameworks, but it is very important specifically to understand the confluence of gender and economy, to understand as to where we stand right now in the country. There are number of provisions, number of empowerment schemes that we have heard over the years, be it in the present government regime or in the past government regime, which have come into force. Some have been able to make an impact, and some have just been like any other policies that were floated for empowerment of women. According to me, these are the 7-8 policies, financially empowerment policies, which I think are making an impact or can make a very worthy impact for the financial empowerment of women. Due to paucity of time, we will not be able to go deep into understanding these policies. So we just run through them. So Mahila Heart is a policy which focuses on women entrepreneurs. It focuses on local entrepreneurs. It focuses on creating empowerment policies by enhancing the skill of women. Beti Bachao, Beti Padhao Andolan is something that we all are acquainted with. It is against female infanticide. It is against female feticide by making sure that girl child is educated. And once a girl child is educated or importance is placed to the education of girl child, there will not be any. There will be a massive reduction in the fantasy of having a male child. Then coming to one-stop center schemes, this has been recently in the last 2 years floated by the present government regime, which states that there has to be a one-stop shop for all the needs of women, be it their skill enhancement schemes or their financial autonomy schemes or even their educational schemes. There are working women hostels which are taking a lot of which are taking into consideration the safe movement of women and as well as financial independence of women. So working women hostels provide safe space to women as well as working opportunities to women. Now, Swadhar Graha is a kind of a housing scheme available for women who are not able to take forward their goals, their ambitions, just because they are victims of certain difficult situation. And by the virtue of this scheme, the government of India makes sure that extra effort, extra resources, extra ancillary services are provided to women who are having it difficult to take forward their particular financial empowerment goals. STEP is an important scheme because it focuses on empowerment of women by taking into consideration their skills that they already have, to make sure that their skills are in tandem with employment, so that there is equal there are equal opportunities to culminate their skill into tangible resources of employment. Now, Nari Shakti Puraskars are accolatory awards given to women who have, through any age, any bracket, any caste, creed, religion, coming from any region of the country, have shown to go against the stated stereotype and achieve something which might influence the other people, specifically women who are looking at them as role models. Then Mahila Shakti Kendras and Mahila Police Volunteers are two very important schemes that were floated by the government of India. Under both these schemes, it's not just about physical empowerment of women, but it is also about taking into consideration that how in fields which are completely male dominated, be it the executive machinery or the ancillary machinery, women can be given a chance to test waters and to establish their own empowerment schemes in these particular industry areas. Nirbhaya is an important financial empowerment scheme that came into being, and it is basically a scheme for women who have been violated sexually, physically, emotionally, and what is the corpus available by the government of India to make sure that their well-being is sanctioned. Right now, the corpus available by the government of India is of INR 10 billion. And these funds will be allocated to make sure that women who are violated are women who are absorbed and women who are cherished and valued. And the Women Helpline Scheme, which is 1091 for Pan India, is a scheme by the virtue of which, be it domestic violence cases or sexual harassment cases or even mental health issues, can be reported and can be rendered. Now that we have seen the scheme, it is very important to understand as to where our lacunas are and what are the recommendations available by the virtue of which economic empowerment can take into consideration the 49% demography of India. So under this, there are 5 key recommendations, and then there are following recommendations after that. The key recommendations are that the representation of women at the parliament has to increase. Right now, there is a pending bill of 33% reservation of women at the parliament. And why is it important? Because there are many a times that there is a debate around merit and representation. But the truth of the matter is that if there is no representation, there are no role models. And if there are no role models, the ambitions are hindered. And therefore, we need more voices of women at the parliament, which can voice out the needs and the requirements of women as a demography. Now, coming to next, which is labor laws to ensure equal opportunities for women. As we discussed in the previous slide, the labor laws, be it in the form of the Equal Remuneration Act, are gender inclusive. However, there is an unconscious gender bias that is practiced by the industries. And what are the schemes, what are the regulations, what are the legal statutes that the government is looking at to make sure that the unconscious gender bias specifically at the workforce is challenged? The third is enhancing the implementation of gender-related laws. So this is basically, be it in marriage laws, be it in family laws, be it in inheritance laws, or be it even in defense forces or sectorial growth. There have to be gender-related, gender-inclusive laws rather than just fragmenting gender to certain particular sectors. Secondary and higher education of women is of extreme importance. The requirement for any kind of...
Pallavi ma'am, I'm sorry to interrupt you. I just request you to kindly wind up as we are really running late and short of time right now.
Sure. So I think, thank you. So I think the rest of the slides, as the implementation of the gender-related laws, education, we have already taken into consideration. Skill training for female entrepreneurs. The next 2 slides are basically on the other recommendations which are required for women economic empowerment, which are on care economy, maternity leave, then investment in public transport, safety areas. Then early marriage prevention law is extremely important. Then conditional cash flow incentive programs to make sure that girls till the age of 18, there has to be incentive programs that they stay in schools. Then differentiation of the market, where the market that brings the most influence to the economy is a male-centric market. Then infrastructure services, which are safety services. Now coming to the last, which is opportunities for women to take decisions in economic at their household or at the leadership position has to increase. Then coming to the resources, which is inheritance laws, specifically in relation to tribal laws or inheritance related to the agriculture economy, have to be streamlined. Narega, then job searching options for women. The other are also the credit benefit facilities for women, or mobile banking apps specifically in the post-COVID scenario. Now coming to the last, which is enhancing quality of laws and statutes for women. In this, employment and entrepreneurship are key result areas, because these are backbones of making sure that our economy is able to float back post-COVID times, and therefore participation of women in both these scenarios is of extreme importance. And the last is that there has to be gender sensitization camp, public awareness camps, by the virtue of which this, what we are studying today in the form of a very brief PPT, is recognized at the mass level, so that gender equality and economic growth can grow together in tandem. Thank you.
Mrinalini,
If I-
please unmute yourself.
Okay.
Ma'am, is there?
Yes.
Should I begin?
Yeah, just a minute. So now we have Shubhangi Agarwalla, ma'am. She's currently serving as a legal assistant to the United Nations International Law Commission, and will be helping Professor Dare Dalby to write books on just cogence, and which is due to be published by OUP. She has been widely published in national and international journals, and recently judged the Canadian National Rounds of Jessup. Her current research focuses on feminist engagement with international law. She's a student of NLU Delhi. So, ma'am, I request you to kindly share your thoughts on these. Thank you.
Okay. Hi. First of all, I'd like to thank the organizing committee at Legal Desire for inviting me to speak. Being one of the last speakers is both a good thing and a bad thing. It's a good thing because I think my co-panelists have done such a brilliant job of laying down the context that I won't have to get into that again. But a bad thing because I'm sure everyone's attention span has started to wane off a little. I'll try to keep my talk as short as possible. As you know, I will be talking about feminist lawyering in India. Before I begin, however, I do want to highlight 3-4 points. First, at the outset, I want to remind us that there are multiple feminist perspectives, sometimes even at odds with one another. So what this means is that saying one is a feminist or calling yourself a feminist does not really mean much, because it does not really equate to any necessary political or moral strategy. And as lawyers, I think we know that words are our most important arsenal. So it's important to be very clear about what meanings we derive from the words that we select. Second, that being said, I think a common theme in all feminist literature is that as a speaker, you should always speak from your subjective experience. And as an audience, you must always be conscious of where the speaker is coming from. So that being said, I'm Shubhangi. I've been very privileged to go to a great law school in India and work with international institutions across the world, including the United Nations, which are traditionally very elite spaces. And as much as I try to deploy my privilege to good use, I think it'll bode all of us well if we take whatever I'm saying with a pinch of salt, because I'm definitely not enumerative of all feminist perspectives that are out there. And third, coming to the theme of the conference, which is on women and child rights, I think it's important to question who is the woman for whom we are championing better laws. Are we when we're talking about women's rights, are we talking about better laws for the Adivasi women in Chhattisgarh, whose land is being taken away in the name of development for India? Are we talking about Dalit women who are manual scavengers despite practically every government coming in and telling us how they're going to get rid of manual scavenging? Are we talking about Northeastern and Kashmiri women who are living in militarized zones? And I think it's very important to put this into context because because your right as a woman will depend upon how your gender intersects with other identities such as caste, class, religion, disability, for example. And just to give you an example, I'm sure all of you are familiar with the case of Tukaram versus the state of Maharashtra, which is notorious in Indian legal jurisprudence, primarily because it involved a young tribal girl who was gang raped in police custody, and the Supreme Court dismissed the circumstantial evidence and the victim's testimony and called it a concoction of lies. And this led to like rallying of feminists across the country who demanded a change in the evidentiary standards for rape. But I think what was missed in their analysis was that the victim in the case was not only vulnerable on account of being a woman. She had a specific vulnerability that arose out of her position as a poor, lower caste, minor tribal girl. And I think that's very important to remember this to keep this in mind. So bearing all of this in mind, let's get to feminist lawyering. Now, feminist lawyering is tricky because by its very nature, it is disruptive. And what this means is that it will upset the status quo, and courts are very reluctant to do anything that might potentially like damage what the status quo tells us. And courts have privileged stability to an extent where they only want to make very incremental changes. To give you an example, there are customary norms which don't allow women to inherit property. But when the court was analyzing the constitutionality of these customary norms, it did not say that women can inherit property. It only went to the extent of saying that out of whatever inheritance you get, you have to maintain the women. But apart from that, feminist lawyering is also tricky because we are accustomed to thinking of the law as representing some moral and epistemological truth. We think of the law as being a neutral entity, and we become so preoccupied with legality that we forget to question whether the law is legitimate or not. And I think the primemost example of this is in our constitution itself. There are certain design choices in our constitution which are problematic. For example, rights only work in the public domain and not in the private domain, which is probably why we've had so many reforms in rape laws, but the marital rape exemption still exists. Further, we also have the restitution of conjugal rights. But apart from the design choices in the constitution, we also have express interpretative choices that the courts make, because of which the constitution allows a lot of discrimination to exist. I think this is amply clear in the case of Geeta Hariharan versus the Reserve Bank of India, where the constitutional validity of Section 6 of the Hindu Minority and Guardianship Act was challenged, which stipulated that only the father can be the natural guardian of a child. And the court read this provision, upheld its constitutionality, but said that in the absence of the father, the mother can also be the natural guardian, instead of saying that the mother has an equal right to be the natural guardian of the child. Similarly, the constitution, on one hand, prohibits express sex discrimination, but on the other, it also makes special provisions for women, recognizing that in society there are several burdens that are placed on women. So if you look at Article 15(3) of the Constitution, it says that the state can make special provisions for women and children. Just tangentially, I think the theme for the conference also deals with women and child rights, which I think a lot of feminists will take issue with, primarily because you don't see any conference talking about men and child rights, right? This infantilization of women that happens is problematic. I understand that a lot, that it's used in UN documents, it's used by the ministries. We have an entire ministry of women and child development. But what this leads to is that it allows the state to take a very paternalistic attitude towards women. And even though these things are said without any malice or afterthought, this seemingly harmless habit can actually have grave implications upon women and their empowerment. For example, if you look at Section 66 of the Factories Act, it prohibits women from being employed in any factory between 6 p.m. and 7 a.m. Now, the court has read this to say that this is constitutional and it does not violate any any articles of the Constitution, primarily, and I quote, because the nature of commitment to family and social environment means that women cannot be entrusted with the same duties as a man. So you see that a woman is constantly constructed as a as a daughter, as a wife, or as a sister. She's not given rights as a citizen by herself. And this is also apparent, the sort of sexual stereotypes that sink into the law is also apparent when you look at rape law jurisprudence, where the harm is not of sexual autonomy or bodily integrity, but the harm is of chastity. Now, what this means is that if the harm is of chastity, a woman who is not chaste cannot be a victim. And that's when you start looking at things like the past sexual history of a woman, on the assumption that a promiscuous woman is likelier to have consented to sexual intercourse. And I think the only outlier in this jurisprudence is Anuj Garg versus Hotel Association of India, which was a 2007 judgment by a two-judge bench of the Supreme Court, which dealt with the constitutionality of Section 30 of the Punjab Excise Act, which prohibited employment of women in places that sell liquor. Now, the court made some very noteworthy suggestions in its judgment. It held that laws such as these end up victimizing those who it aims to be protecting. Further, it held that as opposed to prohibiting women from employment, empowering them is a more socially tenable approach. And lastly, it also gave certain suggestions and suggested that newer models of security, where the cost of security is shared by the employer and the state, is actually going to be more beneficial for women. But I think it's wise for all of us to remember that this is one case and the everyday reality of the court is very dismal. Even laws which are progressive and supposedly women-centric, like the domestic violence laws or divorce laws, which where you have cruelty as a ground for divorce, are grounded in social norms. And this means that the court has said that a woman who does not cook for her husband is engaging in cruel behavior. Now, these are laws which at least have a progressive agenda. Things get more complicated when you start looking at laws which are seemingly completely neutral. For example, the law surrounding the death penalty, which says that the death penalty will be given if the violence is a question of power, of property, or it violates the public sphere. I think it's crucial to remember that women have unequal access to all three of these. Women don't have equal access to either property, power, or the public sphere. So it is less likely that women will face violence in either of those three, and are more likely to face violence in their homes or in more intimate settings. But I think it's practically unheard of for the death penalty to be given on grounds of domestic violence. In fact, I think crimes of passion are actually considered to be a mitigating factor in death penalty jurisprudence. I think I must admit that this does not mean that I'm advocating for the death penalty. On the contrary, I think this just goes to show how the death penalty is inevitably arbitrary in nature. Now, another example of a facially neutral law, which actually has a disproportionate impact on women, is the defense of provocation, which has the qualifier of being grave and sudden attached to it. Now, this discounts the experience of vulnerable sections of society, particularly women, who have to overcome entrenched social conditioning to be able to respond to provocation. So their response will never be grave and sudden. And by including grave and sudden as a requirement and for the defense of provocation, you're excluding women from even adopting that defense in the first place. So I think, all in all, I think it goes to show that in women's movements and in a lot of talks and webinars, we're accustomed to thinking of law reform as the answer. But if we have limited resources, I think we do need to inquire how much we want to invest in law reform or in other areas, because law reform on its own can do very little. Lastly, I do think that it's important to recognize the contribution of these webinars and online conferences, and to use them effectively would be to use them to internally critique the movement and to use them as a means for self-reflection. But at the same time, I think we ought to be cognizant of uh, the fact that this is merely the first step. I think it's important for us to consciously ask the people around us who are championing gender just laws, or organizations which are performing performative allyship, whether they are only involved in optics, or whether they're actually creating structural changes for the benefit of women and other minorities. Thank you.
Thank you so much, ma'am, for your insight. So it was really enriching for us and for our audience also. So I'd now like to introduce Mr. Jayant Bhatt. He's an independent litigator based in New Delhi, India. He holds a dual Masters of Law from New York University, US, and National University of Singapore. Mr. Bhatt is a member of the Supreme Court Bar Association and Delhi High Court Bar Association. The chambers look after matters involving complex and substantial questions of constitutional, commercial, criminal, arbitration, employment, energy, oil and gas, and other related laws in various courts, tribunals, and other adjudicatory bodies across the country. The chambers cater to varied clients comprising of governmental and non-governmental bodies, multinationals, financial institutions, and individuals in an array of matters. So may I request you to kindly address our audience? Thank you.
Thank you so much, Vidusha and Madam Banerjee. I also thank my all co-panelists who have so far shed a great amount of light on the interesting topic of the day, the legal facets of women and child rights. Now, I think as the last speaker, it's also my duty and my privilege to quickly sum up what everybody has said, because my role as a lawyer, and more so as a criminal lawyer, and in this panel as a male, I think it's a little difficult, because there are prejudices against men in general and against criminal law in particular in the country. So just before I commence, I must say, and there's a very famous Urdu shairi, I would start by quoting that. It's saying, "मुझे सुनिए, मुझे नजरअंदाज न कीजिए साहब, मुझे सुनिए, मुझे नजरअंदाज न कीजिए साहब, मेरे हालात से अच्छे हैं ख्यालात मेरे." So having said that, I think there are 2-3 things I would just like to quickly cover up, both as a lawyer and as an officer of the court, because I've had the privilege to be appearing both from the side of state from time to time and also as a defense lawyer in trials and in appellate courts. So when we speak of women and child rights, the co-panelists have already discussed in great detail what are the type of cases and what are the type of legislations which are already in the country, which robustly protect the right of both women and children, whether it be POCSO Act, whether it be Rape Amendment Law, post-Nirbhaya, whether it be POSH Acts, whether it be Maternity Benefits Act, etc., etc. We are also signatory to human rights, to the National, Human Rights Declaration Treaty. So, all that are already in place. The next question is, where do the courts and the lawyers come into play? So we have to realize whenever an offense is reported to a police station, because police is the first pit stop for all these offences to be reported as a crime where FIR is lodged. Then the next pit stop in heinous offences against women, such as rape or sexual molestation, maybe domestic violence, culminating into physical brutality, are then taken up by the hospitals and by the doctors, which has already been addressed by one of my co-panelists. And then later, when all these things are assimilated, police takes into report, prepares the charge sheet, and files it in the court. That is where people like me come into picture to assist the honorable court. So first thing first, lawyers have the last role after all the investigation has taken place, after all the medical legal records have been prepared by the doctors, and after a formal complaint is lodged and the whole process is put into motion. In courts, we have 2 specialist courts these days. One is for POCSO matters, which is prevention of children, prevention of sexual offences against women and children, especially the minors who are 18 years and less. And this is gender neutral. It defines all the genders, men, women, and the third gender. I would say when I speak of women today, I must also include the third gender, as has been also categorized and clarified by the Honorable Supreme Court of India in the judgment of Naxal versus Union of India, whereby the third gender was categorically accepted and they were given the right to fill the form either as a third gender or as male and female. Now, whenever a case is brought to court, when I was just discussing POCSO matter. So in POCSO matters, you have fast-track courts, presided by the Sessions Judge. You also have fast-track matters deciding rape matters, and by and large, they are in-camera proceedings now. At least I can tell you of the Delhi district courts. They have fantastic mechanisms of having a separate trial room for vulnerable witness, whereby a child who is less than 18 years of age, on their complaint, when the FIR is lodged, charge sheet is filed, and the matter comes to court, and when the trial commences, that particular victim, when they are brought as an eyewitness to the case, as a primary witness to a case, they are sent to a separate room in an in-camera proceeding. They are made to sit with a counselor. The next room, the adjoining room, is where the judge will sit and monitor and also adjudicate upon the trial process, along with the lawyers, both from the prosecution side and the defense side. So there are robust mechanisms in place to ensure that transparency and no partiality happens at the time of trial by the judiciary and by the court system. I think a lot of my panelists have also pointed out as to what are the difficulties that even are faced by the police and by the doctors, in heinous offences, both when it relates to women or children. And I think many a time, either out of a social fabric or the traditional thinking of patriarchal mindset, sometimes it so happens that it's very unfortunate, that most of the women either don't complain, or even when they complain, they would have contaminated a crime scene by either taking a bath or having changed the clothes, or some other activity which may have soiled her clothes, or either a finger or something that the doctors have also discussed. And that, I think, dilutes the case of the prosecution a little bit, because when they go to a doctor to obtain a medical-legal report, then the damage is already done. So I think anybody in the audience who is here, listening to the panel today, please make people aware of their legal rights. It's very important, especially vulnerable section of the society. When I say vulnerable, I mean children, and also women who are your domestic helpers, your family, your friends, your near and dear ones, as to what they should do if they are in trouble. I think the first thing that you must always do, and I always tell it to people, is always keep the number of your family and your friends, and if possible, of a fellow lawyer that you know personally or your family knows personally on speed dial. This is besides keeping 100 number also on speed dial, because police is there to protect you, lawyers are there to protect you, the society is there to protect you. Yes, there are perpetrators of crime and there are victims of crime. But having said that, the moment we can conduct these type of webinars, the whole idea is to make sure and ensure that the right message goes to the society. It's not about bashing a gender against the other. It's about how men and women and every gender can come together and create a society which is safe for one and all. It would be wrong to say that men are always a perpetrator of crime. I'll just give an example from a lot of court cases that I have done and I have witnessed, especially when it comes to dowry harassment case or matrimony matters or even domestic violence matters. Where women's rights are many a times you will see a mother-in-law or a sister-in-law fighting against the daughter-in-law or vice versa. So there are allegations and then there are counter-allegations happening in a court of law. There are also cases that I've seen where a male member in a given matrimony setup is earning less than a female member, and lady judges, basically known as Mahila courts, which are presiding the domestic violence matter, have decided in favor of men, also saying that women cannot abuse the law. The law has to be neutral, the law has to be just. The idea of any law, which you read or which comes into being either after amendment or which has been drafted by the parliament and has been eventually given assent by the president and then notified in the gazette, is to ensure that no strata of the society feels weak. It's not about gender neutral laws or gender lopsided laws. I keep on saying, the sake of repetition, that whenever laws are made, they are made to protect people, they are made to protect society, they are made to ensure that the right message goes in the society in terms of protecting children, in terms of protecting women, and even in terms of protecting men, so as to say. Now, there are a number of examples on what courts have done over a number of years. I think one of the co-panelists, one of the senior police officials also pointed out that in the Goswami judgment by the Honorable Supreme Court, the right to privacy was envisaged. Subsequently, in the Navteej Johar judgment, same-sex gender rights were also recognized by the Honorable Supreme Court in 2018. And the whole word homosexual, which traditionally people used to think homosexuality is all about being gay, but later people realized the word homo doesn't mean man. The word homo stems from Greek word which means same. So it means same sex. It can either be man to man, woman to woman, man or woman, or a transgender. So when we speak of children, when we speak of women, I think we must also include transgender into this debate, because excluding them would be doing injustice to them. So I think protecting all everybody, I think the law needs to tweak itself a little bit in terms of including transgenders also into it, because just I think 4 days ago I was in a webinar which was discussing the concept of 377, and 377 somebody asked me, can it be utilized by the third gender? I said, look, it says whosoever. The definition starts with whosoever commits a carnal intercourse against on a man, woman, or beast. So whosoever is very gender neutral, and Supreme Court has also categorically defined that it has to be gender neutral law, which defines consent and which defines anything done against the will or under undue coercion or pressure or stress, or etc. I would also like to just make a minor correction of one of my co-panelists' comment on section 376B and C, because I think my co-panelist said that it is for minor children of 18 or 16 or 12 years of age. I think it's not that. Section 376B after Nirbhaya, when it was inserted, is for matrimonial couple living in separation, and section 376C is punishment for rape by a person in authority. So it's not for minors, it's for women in general who can file a case for under 375, which defines rape under IPC. So I think that's a slight correction for the audience, and I think you should know that, because many times people ask me, matrimonial rape is not recognized in India. So what's how do women agitate their rights? And I say, if you read the law closely and clearly, and if a woman unfortunately has been subjected to unnatural sex or sodomy, you can definitely move section 377. That does not bar matrimonial protection, because it's a separate section in itself and has no relevance to a matrimonial conduct. Also, if you read section 376B of IPC, it says a husband and wife living in judicial separation or separately in their matrimony. Now, I have personally contested divorce matters where in a marriage, if the marriage had not worked for either of the spouses, they have no other place to go to, then they have been living in the same apartment but in different rooms of the same apartment, and that has been recognized as judicial separation. by the honorable courts. So when that can be recognized as a ground for granting divorce or for judicial separation, the same ground can also be exerted by women folk under section 375B of the Indian Penal Code, when if the husband tries to impose himself or force himself upon his estranged wife who is living separately at the time of this separation. So I think all these things have to be taken have already been taken in great regard by the court. And I think over the years, so many amendments have taken place, so many judgments have come, which are, I think, day in and day out supporting women rights and child rights. And I think we are heading in the right direction as a country and as a society. Yes, we have a lot of grounds to cover. I'm not saying everything is hunky-dory, but I think to say that we are not doing anything, or to say that we are lopsided, or to say that we only have a patriarchal mindset would be wrong. If today in 2020 you see the Honorable Supreme Court of India and the Constitution of Judges, it's the first time in the history of this country that you have the most number of lady judges presiding alongside male judges in the country. And the same is true, I can say, even for Delhi High Court, where you see a lot of women judges giving excellent number of judgments and orders on a daily basis. So I think as a society we have really come afar. People, whether it be men or women, are together fighting the right for and are championing the right for both children and for both men and women in this country. And I think Legal Desire on the 7th anniversary has done a stupendous job by bringing such a star-studded panel together, where I could say for myself have benefited from the knowledge of all the eminent panelists who have been here. And also, I think one of my co-panelists just before me is a student in NLUD, and I had the privilege to just teach them 2 months ago in a virtual criminal law trial class. And just so that you know, in fact, the Vice Chancellor or the Dean of NLU Delhi, Mr. Ranveer Singh, is currently heading a committee appointed by the Government of India called the Ranveer Singh Committee on gender-neutral laws. And as you speak, the committee also has, I think, Mr. Mrinalini and 2 or 4 members. And the whole idea of committee is to make gender-neutral laws and also have some criminal reforms, which are much needed in the country, to make sure that the investigating agencies, the judicial agencies, the administrative agencies, to benefit by and large from them. I think I would just pause my speech here because I'm assuming there's also Q&A session and we exceeded our time limit. But thank you again, Legal Desire, for having me among your co-panelists. And thank you very much to my other co-panelists for shedding a great light on the issue, which definitely required a much needed debate today. Thank you. Thank you so much.
Thank you, sir, for your insightful session. Now I please request all the speakers to switch on their videos so that we can proceed to the panel session.
So I welcome all the speakers for the panel session. There are a few questions that have been raised and been asked. So with your permission, I would like to address them. So the first question is to Dr. G.K. Goswami, sir. Sir, as you have been rightly said about filing the charge sheet and the conviction, there has been a gap between the two. So due to which there is also been a delay in collecting the lack of evidence is also there. So sir, what is your thought process that how this gap can be bridged between the filing of the charge sheet and the conviction that happens for the person? And do you think that the court needs to relax the laws a little bit in case the circumstantial evidences are so strong that it shows that the person can be convicted, but the actual evidences, there is lack in those evidences? Do you think the court needs to be relaxed in that criteria, or how do you take this question, sir?
Yes, ma'am. I think I will respond your query in 2 parts.
Yes.
The first one is, you said that whether the collection of evidence has some connotation on time span, right? So let me tell you first thing, that collection of evidence is the part of investigation, right? So collection of evidence has no bearing on trial. Once the investigation is concluded, either it is filing charge sheet or saying that there is no evidence, right? That is called closure report. So everything, collection of evidence, is related to investigation. So first of all, we understand that, right? A lot of people have this, mindset that scientific evidence, forensic science involvement may delay the trial process. No, squarely no. Only thing sometimes is that forensic science laboratory delays sending the reports. That is another point, but it is part of investigation. Okay, number one. Number two, you rightly mentioned that corroboration is very important. I mentioned many cases, especially the sole testimony and many more. So there are a lot of investigation, lot of evidence are there. Unfortunately, our investigating officers are not that well trained, probably. So rather than relaxing the mechanism of trial or the law, I think we should give more emphasis on proper collection of evidence. As Madam Dr. Vidusha rightly mentioned, that medical examination, if you go to rural part, even the say urban many medical hospitals, the doctors are not well trained in forensics. Even the doctors, I have examined many doctors during my research, they have no experience. So I think every stakeholders need training and they're upgrading their skills. That is very important part.
Yes, sir. Sure. Thank you so much, sir. So my next question is to Dr. Vidusha Vijay. Ma'am, thank you so much for your insight. So as you said, what are the medical what are the medical things or the procedures that are being done if there is a patient or a woman or a child who's been abused? So here we want to know, like, what are the situations when the collection of evidences for sexual offenses are lost? Like, what are the criteria in which the evidences are lost so that henceforth the work for the police becomes very difficult? So,
I'm going to rephrase your question so that I hope I understood you correctly.
Yes,
so are you asking me scenarios where the evidence is lost? You want me to enumerate those so that can be corrected in future?
Yes, ma'am. As you've elaborately explained us, like after the patient comes, what are the procedure that has been explained to us very clearly, how evidences are collected. But I want to know the another situation, like which laymen and our audience should know, that what are the situation in which the evidences get lost, so that henceforth the people need to be aware of those, so that such situation should never come up in future.
Right. Yeah. So that's why I mentioned chain of survival and chain of custody. So as a layperson, when you are at a probable crime scene, so what you focus on first is chain of survival. So let's not go into that, but chain of custody. So it's important for the victim as well as laymen, as well as police officers and anybody else to know that it is important that the victim should not be disturbed physically. So there is no combing of her hair. That is the primary thing. So that is where most of the evidence is lost. So even some police constables that come to us, just the PCs or the HCs, they seem to be unaware of this fact that the victim as well as the accused should not be changing their clothes. So they come to us after they have changed, after they have taken a bath, after they have used the toilet. Sometimes using the toilet cannot be avoided, but that is understandable. But otherwise, I think everybody should know that there should not be any changing of clothes. I understand that the victim feels disgusted, she feels dirty, she wants to wash it off. That's a very, primal instinct, that you want to wash yourself and get rid of that. But it's important that she doesn't do that. So that's why it's important that within 24 hours of the incident, they bring them to the doctors for examination. So let it happen as soon as possible so the victim can be comfortable. So that is the most important part. That's where evidence is lost.
Okay. Thank you so much, ma'am. It was really helpful. So my next question is to Advocate Bhatt, sir. Sir, I wanted to know, I think even the audiences would love to hear from you, that as you being an advocate both in the Supreme Court and in the Delhi High Court, there have been an n number of cases on sexual offences towards women and child. But if we see that supposedly today, if a case comes, judgment takes a long period of time, even if we see the Nirbhaya case. So the general tendency of people in this scenario is that a delayed justice is denied justice. So how can that be overcome, or what is your suggestion that can be done so that actually cases where sexual offences have taken place to a heinous level or to a very grievous level, that can be shortened down the period of delay?
Madam, I think I have got two suggestions. Number one is legal literacy across the country, and it starts with us schools and colleges, because I don't think law as a subject is taught, or the basic legal awareness is put across the citizens at large of this country, which I think is lacking. The other is legal funding, which the courts or the judiciary ought to get from the government, either the state government or the central government. Without requisite funding, and it's not just one Nirbhaya case, there are also cases which are expedited and which are heard quickly. Nirbhaya case, unfortunately, was one of the cases which had a national highlight to it. And because the accused, did everything in their power till the last resort to go to the president as well, for any capital punishment pardon. So that was one thing. Now, if you see the timeline of Nirbhaya matter, there was a fast-track court which was appointed, and both the public prosecutor and the defense lawyer, within a time-bound manner, came out with the verdict on the trial. Subsequently, because as law requires, they had a right to appeal to both the Delhi High Court, because it was a Delhi-based case, and then to the Supreme Court of India. And that, I think, got concluded again within time. Now, you have to realize when a person goes to any trial court or High Court or Supreme Court of India, we have limited number of judges working for the country. And that's why I say, besides legal literacy, we need a legal budget. I'll give you an example of Supreme Court. Now, Supreme Court has a sanctioned strength of 34 sitting judges for a population of 1 billion people in this country. You can do the math yourself. It's really, really discouraging, the data. You see the number of sanctioned sitting judges of Delhi High Court. I think about 60 judges are sitting, or 30 judges. It's just working at, I think, 60% capacity, the Delhi High Court. And it is not just one Nirbhaya case that they have to hear. They have to hear every type of litigation which comes to them. Judges keep getting transferred. They have a roster change. Everything is there. So to say that judiciary is not doing anything, there is a judicial delay. People need to come to court either doing their internship, and I think some schools have started internship. I'll give you an example. I was sitting in Facets family court, I think in a pre-COVID time, and I was sitting in the family court, and about 25 to 30 girl students from a girls' school were brought to see how family court works. And I think that is a good step. People need to see how police courts work. People need to see how judiciary works. And Dr. Goswami is here from CBI. He would know, and as a senior officer, there is tremendous amount of pressure on a government servant. Either you are the police, or you are a judge, or you are a public prosecutor. You have to collate so much of information. Now imagine this. In Nirbhaya case, if there was a botched up investigation, or if the police was not to do its investigation properly, the prosecution would not have been able to establish a case. So, police also have to do their job properly, and that takes time. It's not a 2-minute Maggie noodle that a crime has happened, and then again, as Dr. Vidusha also said, the first, the victim comes to them, and they have to ensure that the medico-legal report goes into place. So, and while the police is monitoring all this, the prosecution has to ensure that the charge sheet which is being filed in a proper manner. There are a lot of dynamics which go into play. I would not be quick to blame the judiciary. I think people need to come to the judiciary and actually see some of the pitiable conditions under which the lower court judiciary is working. And I'm not telling you of Delhi. Please go outside Delhi. 50 kilometers, 100 kilometers outside Delhi, there are courtrooms which don't even have windows. There are courtrooms in which the roof is leaking. So, there's very displeasing conditions on which our lower court judiciary is working. And I think we need to be a little more sympathetic to our judiciary, and people actually need to raise their concern and voice to the government, who takes money from the taxpayer and unfortunately is not directing to the judiciary.
Sure. So thank you so much, sir. So my next question is to Ms. Pallavi Mahajan. Ma'am, as you've been an UN volunteer, we would love to hear from you that how is UN right now addressing to gender equality and maintaining it in India, if at all it is?
So, the UN is an international organization, and
Yes.
it works very coherently with the governments to make sure that certain sustainable development goals are followed at the government level. But at the end of the day, we have to understand that it is not a statutory body. Whatever is decided at the United Nations level is to be, in the colloquial terms, a goodwill ambassador program for the countries to follow suit. It cannot be taken to be news that the government has to follow. The regulations right now for Sustainable Development Goals 2030 are very apparent. It is all about financial independence and empowerment of women. And where India has taken consideration of their goals is that India turned 75 in 2022 and 2022, yeah. And one of the key goals of India at 75, goal number 24, I think, is gender parity, specifically gender parity in financial distribution. So therefore, in that parlance, India is working in tandem with financial stability of women. Consideration of various policies which are right now under the purview of the legislature is also again on how are we including the representation of women. About 2 months back, Sweden floated its first feminist trade policy. Sweden floated its first feminist trade policy in 2017, and then Mexico, which is also an emerging economy like India, floated its feminist trade policy about 2-3 months back. And though I understand feminism is supposed to be a very tabooed word in India, nobody wants to use it because they think that all feminists are these angry women who are only there to burn flags down. So we call them equalist policies and not feminist policies. But yeah, a lot of international trade and foreign relations are taken into consideration. And I, as a person, always takes the glass half full. So even if the government might not consider things to be at equal parity, I believe that one day they will. And that is why it is very necessary, and specifically with the panel that we have today, to have allied forces, no matter where we come from, what our political ideology is. But I'm sure that we all stand that, specifically in regard to the gender, we all receive equal representation and equal opportunity. Thank you.
Sure. Thank you so much. So my last question is to Ms. Shubhangi, ma'am. So, ma'am, we want to know, how do you think the quality of implementation of laws for a child can be actually done in India? As we see, our first speaker, Dr. Goswami sir, has already said that there is no inadequacy of laws as such. There are laws, but when we actually come to see whether the execution has been done, implementation has been done, there is a gap between the laws which are there and the implementation. So what is your take on this, or how do you think we can bridge up this gap, or we can overcome this problem?
I think I would like to qualify that statement a little bit. I think rather than saying that there are already a lot of laws, I think what's important to note is that there are a lot of criminal laws as opposed to looking at other avenues of laws. And this, I think, as like my previous panelists have already pointed out, is not very effective. So, and this is a critique that's been leveraged across like most areas of sexual assault by feminists, that adopting a carceral politics to implement any change has not proven to be fruitful, because ultimately the people who are caught under a very carceral logic end up being low socioeconomic offenders, or people who fall low on the socioeconomic spectrum. So I think there is a possibility for us to look at for us to look beyond just criminal law, whether it's through labor law tribunals or certain other avenues. I think that's a very significant possibility, because I think there's another scholar by the name of Prabha Kotiswaran who actually speaks to this regard. She talks about how India has been so focused on adopting international precedents and what's happening in America and what's happening in Europe, that it's forgotten how it can use its own laws, how certain provisions of its own constitution can actually be utilized for women and children's rights. For example, Article 23 of the Constitution. So I think these are other possible avenues other than, of course, like improving education to help women and children.
True. I also consider that to be true. Even if we see the Vishaka versus State of Rajasthan, the court had given the guidelines way back, but we got the act almost like 2 decades after. So which is your true in the fact that we see that even if the courts are helping out, the act coming out, it's really takes quite some time and then implementation. So thank you so much. It was an amazing panel here for us all to hear, and I'm sure our audience have really benefited. We also have been benefited from it. So I now request Mr. Ijaz Muhammad sir to, if he could kindly give the vote of thanks.
Am I audible?
Yes, sir.
I deem it a great honor and privilege to propose a vote of thanks for this occasion, which couldn't have happened without the existence and presence of many people. First and foremost, I wish to thank our esteemed resource persons, Dr. G.K. Goswami sir, Prakash sir, Jayant sir, Vidusha ma'am, Pallavi ma'am, Shubhangi ma'am, and our moderator Mrinalini ma'am, who has taken time out of their busy schedule for this conference. I am thankful to our founder and editor-in-chief Anuj sir for their instant support, guidance, and for constant encouragement to make this conference a grand event. I also thank all the participants and my colleagues for their cooperation and hard work to make the conference a resounding success. I would like to extend my thanks to our supporting organizations, Department of Forensic Sciences, Legal Design, GTN Arts College, Bioforensic Research Center, Italy, Digital School of Law, and the Tax Assurance. The participants kindly note the certificates of the conference will be sent in a week time to your registered email ID. And do subscribe to our YouTube channel, Public and Policy TV, and follow Legal Desire and social media handles to get updated with the latest legal issues and insights and updates. Thank you.
Thank you, Vijay, and thank you everyone for joining us.
Thank you very much.
Thank you.